We'd like to welcome everyone to the Centerville City Council being held on November 16th at Centerville City Hall. We welcome all those that are present in person. We welcome all those that may be joining us online as well, and we thank you for your time in being here. Welcome the staff and council here as well too, and are grateful grateful for their service and the time that they put in doing these things and taking care of our city. Let's make sure that we can proceed with the business of the meeting by doing a roll call vote, starting on the far left with Councilwoman Fillmore.
Present.
Ince, present.
Meekum, present.
Ivy, present.
McEwen here.
All 5 council members are present, and once again, I thank everyone for being here. The first thing that we'll do is prayer thought, and that is mine today. With Veterans Day being last Thursday, it got me reading about some veterans celebrations and activities that have taken place over the years. And one of them that I read about was President Ronald Reagan on June 6, 1984, going back to the beaches of Normandy and commemorating this 40th year anniversary. And there were 62 of those men that stormed that beach with him that day. And he said to them, "You all knew that some things are worth dying for. One's country is worth dying for. One's country is worth dying for, and democracy is worth dying for, because it's the most deeply honorable form of government ever devised by man. All of you loved liberty, all of you were willing to fight tyranny, and you knew the people of your countries were behind you. The Americans who fought here that morning knew word of the invasion was spreading through the darkness back home. They fought or felt in their hearts, though they didn't know, in fact, that in Georgia they were filling their churches at 4 a.m., in Kansas, they were kneeling on their porches and praying, and in Philadelphia, they were ringing the Liberty Bell. Something else helped the men of D-Day, their rock-hard belief that Providence would have a great hand in the events that would unfold here, that God was an ally in this great cause. And so the night before the invasion, when Colonel Wolverton asked his parachute troops to kneel with him in prayer, he told them, 'Do not bow your heads, but look up so you can see God and ask his blessing in what we're about.' On his cot, listening in the dark for the promise God made to Joshua, 'I will not fail thee nor forsake thee.' These are the things that impelled them. These are the things that shaped the unity of the Allies." And I will give a prayer as well. Our Heavenly Father, we're very grateful for the opportunity that we have to gather in this free country and free state and free city, and to be able to discuss the matters of our great Centerville city this night. We ask a blessing upon all the residents of the city. We ask a blessing on those that fight and protect our country, and those that fight and protect our city. Help all of us that we may be good citizens and honor the rights that we have, and obey and follow the law. Bless us at this time that we may be able to have harmony in our meeting here and have discussions that are fruitful and beneficial. And bless all those that, once again, that serve throughout from our country throughout the world. And this we say in the name of thy Son, Jesus Christ. Amen.
Amen.
So, Stephanie, Councilwoman Ivy, I'll turn it over to you.
Will you please stand and join me in the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you, everyone, for joining in that. The next item is we'll do an open session. Now, keep in mind that we do have 4 public hearings tonight on the Summerhill Lane, on the zoning code amendments and the internal ADUs, on the floodplain development variance, and on the Davis County pre-disaster mitigation plan. So if you are going to comment on any of those 4 things, we will have separate time for those 4 things. So we're looking for, outside of those items, which you'll be able to comment, like I said, at that point in time, anything else that may be on someone's mind that they want to discuss. If there is, just come forward, try and keep your comments to a couple of minutes and just identify yourself and where you're from. So the open session is now over. For those of us, or now open, excuse me, not over, now open. For those that want to join on, call in, you'll see it on your screen, and I will look to our city recorder, Jennifer, see if there's anybody that's calling in. So welcome to those that want to comment. Come on up and just introduce yourself and where you're from.
Okay. My name is Libby Dibb. I'm a resident in Centerville. My concern is about bus rapid transit, and I just wanted to address the alternate route, and I think it should be on the agenda for the city council. So during this election, there were a number of comments made by the mayor, Mayor Clark Wilkinson, and his wife that indicated you've been in contact with Beth Holbrick from UTA and been looking at other route options for bus rapid transit, which is presently planned to go on Main Street, and that you had our best interest in finding a location other than Main Street. So also just to confirm, I did look at your website on campaign. I just want to present some promises you've made. That UTA is presently working on a bus rapid transit system. So this is from Mayor Clark Wilkinson's campaign website. And that bus rapid will run between Salt Lake City and Farmington. The plans do not include not for dedicated lanes. UDOT currently has plans for the route to be on Main Street, but Mayor Wilkinson, a strong proponent of business, has proposed to UDOT to redirect it down Lund Lane, turning onto the frontage road through the business district of Marketplace Drive and 400 West. Once again, this is a bus system and not light rail. Some form of bus service will still be available in the east part of the city. So I really appreciate this promise. I think it's great to have efforts on this. And so I'm just asking that, again, to be clear, that if the council will put this, put on the agenda the bus rapid transit alternate routes to be discussed as the council. I did talk to one council member today who said they were not aware of alternate routes at this time. And if you could specifically just address what's been promised and how you can implement it, I just think it would be great. And I also think it'd be fair and helpful for the community to be able to have a part in these discussions. Yeah, so I look forward to seeing this discussed.
Thank you, Libby. We can definitely get in UTA in for a discussion. Thank you. Any further participants in the open session? Are we seeing any online, Jennifer?
Nobody's raised their hand. Nope. Oops.
We probably gave them enough time to come in online as well too. Jennifer says that she's not seen anyone, and if there's nobody else here to discuss anything in the open session, we will close the open session and we will go on to item E on our agenda. This is the business of the meeting. The first item on the business of the meeting is one of the public hearings I talked about. This is the Summerhill Lane PDO final subdivision plat. This, like I said, is a public hearing, so we will hear, staff will introduce this PDO first, and then the applicant will have a chance if they want to talk, and the council can ask questions, and then we go to a public hearing at that point in time. So staff, is it Corey, are you going to address it?
Thank you, Mayor, members of the council. As indicated, this is a business item for the review of the final plat for the Summerhill Lane subdivision with Symphony Homes being applicant. You have a long meeting and agenda, so I don't cover the details. Would be here for your questions, but just by way of a couple of items for clarity. so that everybody understands how we got to this point. Nearly 2 years. A lot of different factors played into that role of 2 years, so just want to step back so that everybody's clear about the procedures, because there's been some questions in my office about that. The Summerhill Lane property was originally zoned agricultural low. The request was to bring it into residential low. In those discussions, Symphony was instructed to come back with rather than just a simple rezone of the property to RL, they were instructed to come back by the city to do a plan development overlay. As a part of that, some of those concerns were particularly about infrastructure construction and not be done in phases, interrupting some drainage issues, some relative large picture elements to the subdivision to be built in one single phase. In that discussion afterwards, he did come back in with a request for a plan development overlay along with the rezone, and that alters the nature of the process to some degree. Rather than looking at it just simple rezone, the plan development overlay now is an option to negotiate to some extent the development of the property. So part of that discussion in the PDO, it involves a conceptual layout of the subdivision, and that conceptual layout is tagged along with the PDO development. And so the concept of subdivision review, concept of the rezone are merged into one public hearing process and decision by the city. At that time, it was, concept plan showed roughly around 63 or so lots to be developed. They would build the project as one large development to tie all the infrastructure and the storm drainage system into one development, and then the lots would be sold at a later time for development. Part of that negotiation and discussion was the roadway layout. There was not, under the general plan of the city, a requirement to connect to the frontage road. That was an intensive discussion to do that. Ultimately, the city required that the internal roads have a connection to the frontage road. And so that road was then put into place. Part of also that discussion during the PDO was the varying lot sizes. The idea of changing to RL is to have a variety of lot sizes to try to hit a little different market prices into the homes. It was decided that the smaller lots would be on the west end and some larger lots would be towards the east. There's also discussion during that time, snow removal, and they showed the locations for the snow removal. Also the idea, the consideration of the block distance for the subdivision was discussed. And typically you have an idea that about 800 feet, the city may require a walkway to split through the subdivision. That discussion ensued with the school district. The school district did not want lots fronting along the road, wanted it to secure, so the school district had sold some property. So the walkway disappeared at the 800-foot mark. The discussion of the 1,200-foot block distance took place, and the Planning Commission and the city decided that there was not a need for a road to cut up that block, and so we're reaching about 1,300 feet for it. It also altered some of the setbacks, particularly for some of the smaller lots, allowing some reduction into the setbacks. Why is this important? Is because the PDO is partially negotiated. It becomes its own zoning and subdivision product, and it's customized. And during that process, the city can waive requirements. So the block distance requirement, the waiving of the setbacks was also a part of that. So there are a number of things that changed because of the PDO, and the idea was to get a better development. In this case, the better development was a connection to frontage road, and the utilities all be built in one phase of the project. So a public hearing was held during that time. The rezone was passed with that concept plan. The next step in the process is to take that to preliminary. It took some time to bring it to a preliminary subdivision level. The preliminary is reviewed by the Planning Commission only, And the planning commission also conducts a public hearing at that level of the preliminary. That's their shot to look at the details of the subdivision, because the PDO is that concept plan. Now we're working through some of the engineering and layout. It's also a public hearing for the public to come in, discuss what they might see, some of the compliance with the PDO approval. And that public hearing was conducted. Planning Commission passed that public hearing. After the public hearing, they passed the subdivision. There we go. Just by way of disclosure, that is a decision of the Planning Commission, and because it's a decision, it can be appealed to the Board of Adjustment. And it was filed an appeal to the Board of Adjustment shortly before the meeting, a few hours before it was being conducted. Symphony Homes and the appellant came to an agreement to settle that. And the appellant withdrew their application for the appeal. Please understand that that appeal or that settlement was between Symphony and the appellant. It did not bind the city per se. There was an advantage that we didn't go to the appeal hearing, so there was a withdrawal, which then finalized the decision of the Planning Commission at that level. But the appellant was indicating that the preliminary shouldn't have been approved for a number of reasons. And then they settled that disagreement with Symphony. So the next step after that hearing is the final review for the subdivision. The final review is 2 steps now. The step at the Planning Commission is only a recommendation, not a decision. And then the Planning Commission reviews that against their preliminary approval and the ordinances and the PDO that are applicable, makes a recommendation to you. That meeting was not a public hearing. It was a public meeting, but it was not a public hearing. There were those that did desire to comment during that meeting, and I indicated in email communications that it was not a public hearing. It would be best that they prepare for the city council. And this is where the city council would conduct a hearing. So that's why the public didn't participate in that final review by the Planning Commission. Now tonight we're here for the final. You're receiving a recommendation from the Planning Commission. You're also looking at the ordinances, and you're going to conduct a public hearing. This public hearing is designed for the public to comment on compliance with the PDO approval and any applicable ordinances. Just by way of procedure, because there's questions being asked about it, the petitioner owns the application, and so the petitioner is the entity that's given the time to make the arguments that their development complies with ordinances. And so at some point in level, we have to allow that. They own that application through every step, and so that's why Symphony did make comment at the preliminary, or at the final for the recommendation, but it was not open for public comment because that was to ensue at this meeting. Typically what we've done, so that we're kind of on the same page, staff makes a presentation. I'm going to just merit some issues and then end, and you can ask me questions or hold off later. Typically, at the Planning Commission and here at this level, you allow the applicant to address their petition to you. And then after they conclude their remarks, and this should be allowed for everybody of the petitioner, whether it's an architect, whether it's an engineer, whether it's the petitioner themselves, this is their time to make their case of whether they comply with the ordinance. Then you'd conduct a public hearing, and that's typically what we do at the Planning Commission. You conduct that, you decide whether to close that hearing or keep it open, depending on what you believe is going on in all of the debates. If you did close the public hearing, you can continue to ask questions of staff or the applicant so that you get clarity on the petition. And then to be fair to the debate, we typically allow the applicant the final word in the process. Obviously, Mayor, you have the chair duty, so you get to handle the logistics of this all. But I just wanted everybody to know over a 2-year period, this is what's been going on for. And now some highlights to the development itself. In review during the planning commission level, and staff is participating in that process. We included review of what was passed in the PDO and those applicable ordinances. The preliminary was decided upon by the planning commission. And their review to the finals to see compliance with that. And their recommendation is that it did comply with their preliminary approval. I anticipate we'll have some debates about that though. So we can debate that as we move forward. It's 63 lots. It reflects the preliminary plan. It reflects the road. It reflects the infrastructure all built in its entirety. So we believe it meets the merits of the ordinance. And, you know, one thing staff has tried to be very disciplined into this process on every application is that we get constant training to stay within the boundaries of our ordinances. Although we can debate the boundaries of what that is, our recommendations will always try to stay within that boundaries. Because that's when we open ourselves of making decisions outside of what our ordinance is. And then that induces risk on whether we were fair to the process in accordance with our code. So I can answer some detailed questions, but we believe it complies with that PDO approval and the preliminary with the planning commission. It is recommended to you, I believe, the report to you is 4-1 in the vote with one abstention. So it is a majority recommendation, not a unanimous recommendation. And that's why I anticipate there'll be some questions and debate. So the recommendation is to approve.
Any questions at this time for Corey?
Do we know why the one voted against?
I'm not.
Did he vote against or abstain?
No, one abstained, one voted against.
One voted against, did not make if I recall, a record statement about the dissension vote. Obviously, there were some debatable issues and they didn't agree with that. The one abstention, I can only surmise the abstention. And I couldn't speak for that abstention. You know, the summation is that there was, you know, the abstention is a person who carries a law degree and is also wearing the commissioner's hat and felt the tug and pull between the debate as an attorney and the debate as a planning commissioner, and that's about all I could surmise of why.
Neither one of them stated why, but, okay. And then, if no questions for Corey at this time, then applicant, do you have any presentation before we go to a public hearing?
Yes, I do, Mayor.
Come on ahead and introduce yourself.
Thank you. Melvin Smith, attorney for Symphony. I live at 1936 East, 1900 North in Layton. And I do have a PowerPoint presentation, and so I might need some help to get it hooked up so that you can see it. I assume that what I have will end up on your screens. Is that correct?
Yeah,
Just right here, not on your
to
individual screen.
the public.
Okay. Ms. Hanson, do I have a connection here?
It's a screen share. She can do it up here.
Oh, you can do that?
This is your PowerPoint, right?
Okay, yes, uh-huh.
Yeah, if you just want to tell me next when you want to move forward, then I can,
Okay.
Don't use the film
Slide
strip
screen.
noise. That's not going to mean anything to her.
Okay, that
don't
sounds
be
good. I might get mine going so that I can see mine as well. And can you hear me okay if this computer's here? Okay.
Yes.
Yeah, that sounds like a nice mic. Well, I'm going to have to go into my subdirectory. I saved it on my hard drive, and it is not there, so. By the way, Mayor, I very much thank you for your remarks. We need more of that, and so I'm grateful for that. I have a neighbor that brought in an Afghan refugee, And as we talk to him, his story is just harrowing. And I have a newfound love for this country and our freedoms. It has been quite humbling to see that. Okay, let me thank you. I think I about have it. Okay. Just a couple of tidying up items. Earlier today, we had dropped off a list of documents that's 2 pages long. I believe you received those, along with a pretty good stack of documents for the record. I formally introduced those into the record. We're going to be probably a little bit more thorough today than normally, just because there was an appeal on the last round, and both sides are going to be pretty meticulous at making sure we have a good, solid record, just in case that happens. We're not anticipating that, but we never know.
Are these documents, you gave them to the city recorder today?
Yes,
So the council has not had an opportunity to review any of these documents?
That's correct.
So I guess, I don't know how the rest of the council feels, but I don't want to do an in-depth review of documents I haven't read.
I don't believe we should as well.
Yeah, they're just, most of,
Reference them, but I don't want to do a deep dive on a document I have no context to. I'm just being honest, I don't like that. You talk to any staff member in the city, they'll tell you, I read everything that comes in, even if it's really long. So just presenting documents to me in this format that's frustrating. I'll just be honest.
We normally get these documents on Friday, and we'll accept them up to 24 hours in advance, so Jennifer could post something maybe like yesterday. But yeah, anything that you introduced today that we haven't had a chance to look at.
Okay, yeah, most of those documents, what you'll find, they're really just listings of a lot of the documents that are already in the record. It's just that we don't always know. Most of them are like hearings and administrative recommendations, council or planning commission holdings, those kinds of things. So a lot of those documents, it's a checklist just to make sure that they're here at the city, and if not, then we'd provide them.
So we'd like to proceed forward, Melvin, with just your applicant on the subdivision as a whole.
Okay,
We're not
thank you.
sitting here to discuss legal
Thank you
issues.
for that.
We just want to see your presentation on the subdivision.
Okay, thank you. I'm skipping over some of the items because they've been covered. We're here for the final plat approval, as you know, and the applicable ordinance, city ordinance is 15-410. It requires 3 major steps. First was the, as was mentioned, the Planning Commission approval, which took place on April 28, 2021. Secondly, the Planning Commission review of the final plat, which took place last month on October 27th. And then today, the approval by the City Council. Ordinance 15-0410 gives the purpose for this meeting, and it's always important to know where we're coming from. We're going to be stating some of those standards today, but quote from the ordinance, to ensure compliance of the subdivision with applicable ordinances. And so it's a pretty simple hearing. You know that you're sitting here as an administrative body, not as a legislative body. And the standards, and if you could go ahead and go to that first slide. Thank you. If a land use regulation, I'm just quoting now from the Utah Legislative Act 109306 in LEDMA, and I'm quoting that verbatim. If a land use regulation does not plainly restrict a land use application, the land use authority shall interpret and apply the land use regulation to favor the land use application. In other words, tie goes to the runner. in the legislature, they really do protect property rights, and so they look at a balancing of the right to regulate from the city standpoint as contrasted to the property rights. And if there's an issue that's kind of close, it usually goes in favor of the applicant, in this case, Symphony. The next citing is a land use decision of a land use authority is an administrative act. Boy, I all of a sudden got really thirsty. There's not any water. If there's one, I would appreciate it, because I'm starting to have a hard time. Thank you. Can I approach? That's perfect. I wasn't thirsty when I got here.
No problem.
Thank you. Okay, so a land use decision of land use authority is an administrative act. You know that, and that's what we're here for. And then a legislative body may enact a land use regulation only by ordinance. And I've had that happen. I do a lot of this work. Occasionally, sometimes city council can get confused and say, well, we need another ordinance so that we can hold a certain way. That can't happen because it requires an ordinance. And so we're really looking at the statutes that are in existence right now at this time. Slide 3, if you can go to that. Okay, thank you. Ordinance 1501-120 then says that decisions regarding an administrative application shall be based on substantial evidence. And the contrary to that is we get into trouble as a city council. I'm also attorney for Ogden City, and so I kind of know how this goes pretty well. And if an issue ends up that there's substantial evidence that leads to a decision, and if the council goes another direction, ignores substantial evidence, that can be termed arbitrary and capricious and outside of what the city council should be doing. And so the next item is the city council decision includes, among other things, specific reference to the standards set forth in the Centerville Municipal Code. In other words, in order to not be arbitrary and capricious, I know this is a review for you, but you have a code, and we're going to go over quite a bit of that today. And if the subdivision complies with the code and the substantial evidence leads to that effect, then a decision should follow. And then on state statute, on slide number 4, if you would go to the next one, thank you. In Utah law, this is in 10-9603, that if the plat conforms to the municipality's ordinances, so you have the ordinances, you have your statutory scheme, you've got the plat, the staff looks at it, they review it thoroughly, and then the municipality then should approve the plat, and it says shall, so in other words, if it complies, it is approved. And there's a ellipsis there. What falls in between are some other approvals from water, sewer, and those kinds of things. So I left out the complexity there. Okay, the next slide, if you would, please. Thank you. I think Corey, he handled this quite well, but the timeline, I was a little surprised. I mean, this is our 12th time that we've been here on a matter, so it's been a long process. Grateful for the city's efforts. There's been a lot of time spent as going over a 2-year period, but the 3 most important I've referred to there are the approvals from the Planning Commission and then today. Okay, if you go to the next slide, please, number 6. What I'm going to do is, again, the issue is compliance with the ordinance and with your own code. And so I'm going to go through quick. I'm not going to go through each item because you don't need that, and a lot of but if you look at slide number 6, that is a listing of all of the Planning Commission checklist items that had to take place. And if you go to the next slide, it shows just a little bit more. Yeah, there you go. And everything has been complied with. The only issue that there might be, and I'm going to address that, is number 9. We agree it's been done. Staff agree that that's been taken care of, but I think Mr. Packer might have a different opinion on that still. And that one says the final plat shall comply with Centerville's zoning subdivision code 153030. Some confusion there because the planning, the preliminary approval stage is 1503030, and that requires only that those items that, and I'll get into more details on that a little bit further, but it requires that certain easements be placed on the plat, and those easements were placed on the preliminary plat, and that was pursuant to an agreement that we had made with them. There's been some confusion because in some of the information from Mr. Packer, it refers to 1504-030, and that's the final plat approval. The final plat is a different standard, and we'll get into that a little bit later. So actually, what the Planning Commission said is, on the preliminary plat, you have to have some easements. That was by stipulation. The easements were on, it complied, and so all of those requirements have been fulfilled. Okay, if you can go to the next slide, please. This is a listing of, now this is 1504-30, which is a recitation of all the things that your ordinance requires that has to be on the final plat. And again, I'm not going to go over those other than to just scroll through those that we've listed. Everything in the ordinance, we've checked it, it's all in the record, they've been fulfilled, and it complies with the staff recommendations. So if you can go to the next slide, please. And then the next one. This is just showing those one at a time. Paragraph M we'll come back to in just a little bit, but go ahead and go one more, and then one more. So everything has been complied with there. This gets beyond what is required on the plat and goes into the preparation for the construction plans which have been submitted. And then in 1504-50, it requires, as we mentioned, the Planning Commission recommendation. That's been satisfied. Next slide, please. And then this is the plat, and all the documents have to be reviewed and approved by both the city engineer and the city attorney. That has taken place. The next slide, please. And so that brings us to that everything has been buttoned. I mean, we have several meetings. We have several staff reports. We've gone over exhaustively of all the ordinances and all the requirements, and they've all been satisfied. Those things now put that, I kind of put the easement issue on the shelf, and I'm going to come to that now. So as a separate issue then, there was a claim of two easements. One, a prescriptive easement on the west side of north of 400 West, and we'll show that plat in a minute, and then a claimed easement of record running along the north side of the Symphony property. In this slide, this shows the standards on what has to go on the plat and what does not. And the preliminary plat requires the location, principal dimensions, those things about the easement to be on the plat, whether recorded or claimed by usage. That's where there was some issue, whether or not the standard of that plat, of the claimed easements hit the standard where they need to be on the plat. We resolved that, and so that's no longer an issue. On the final plat, though, so they went on, so we hit, on the final plat, it's a complete different standard. And the reason for that is on the preliminary plat, there's an interest in the city to be able to look at the plat and see what potential easements could come up, and then what the impact would be on the infrastructure that's going in, on the utilities, the easements, and those kinds of things. Once that is reviewed by staff, and it's determined that, okay, even if the worst case scenario happened, if something is claimed by usage but not yet perfected, hasn't been litigated, it hasn't been perfected, but if it doesn't have an impact, a negative impact on the subdivision, then it's okay, we can move on to final. So final then, that's a different standard. It's all existing and proposed easements shall be clearly labeled and identified. And so that requires actual easements, not just claimed easements. And so intentionally, the city council, probably not you, but your predecessors, made that decision that we don't really care about claimed by usage at the final stage to go on the plat, because there might be a lot of claims that never mature into an easement. And then why have it encumbering all these plats? Okay, go next slide, please. This represents, and so now we're going to talk a little bit more about the claimed prescriptive easement, which would be on the west side of the property. And this was a letter by Mr. Anderson, Matthew Anderson, Mr. Packer's attorney. And this was in the appeal letter that went to the Board of Adjustments. And in that letter, it's really made clear, and it's hard for me to even see that, but it says that this easement, do you mind if I'm not looking at mine, I probably need to catch up on my own. What number are you on?
15.
15? Okay. Okay, so that, it says, the Packers are also entitled to a prescriptive easement from the north end of the 400 West stub to their property. This is not an easement of record, but one claimed by usage. So an admission there that the prescriptive claim is a claim by usage. It was put on the preliminary plat, not necessary by city ordinance to put it on the final plat. And there really is not much debate on that one, to be honest with you. It's right black letter out of the ordinance, and then by what is admitted in the appeal. Okay, the next item. But if there were some questions there, and I'm not going to go after this too much, but whether or not there's a prescriptive easement is really an issue of litigation. You're a legislative body, sometimes you're an administrative body like you are, and then there is a judicial body, and the judicial actually is equipped to handle all of the complexities of whether or not there is an easement there. And that's going to be handled not at this level, it's going to be handled in a court of law. There's the elements, I'm not going to go over those because it's beyond the scope of what we need to worry about. But I will show, if you go to the next slide, that this shows both the Symphony property and Mr. Packer's property. The yellow, if you look on the left-hand side, that's a small piece of property that he's owned for more than 40 years. It looks like that was in the Bamberger right-of-way at one time. And then on the other side, on the right-hand side, that's the larger property that he purchased in 2015. It's on that property that there's a claim that there's an easement running along that property in the Symphony property. But if you look at this, the crosshatch section is the land that Symphony has owned for over 20 years. And if there were any kinds of uses taking place, Symphony would know, and they and their predecessors have signed a statement that all of the uses were by permission. If it's by permission, then it's not by prescription. If that proves to be true in a court of law, there will never be an easement. So it's very much in dispute and not necessary to put on the plat. Okay, the next item, if you would, please. The next issue is, so that handles the prescriptive. Now we're looking at the other easement, that the claimed easement, that it's of record. This slide shows the Packer warranty deed where he received title from Ostergaards in 2015, and on the right-hand side you can see the legal description. There is no listing of an easement in that deed, none whatsoever, and this is the issue of whether or not there is an easement of record. There is none of record in that deed. And then the next page, this is the Ostergaard deed, where they received title from Rigby's, and this dates back to 1972. Has the same legal description. There is nothing in there that shows that there's any kind of an easement. Usually what you would have in the legal description is you'd have the meets and bounds description, and then you'd see something like together with an easement over and across a piece of property. And that's not in there. So that gives you a 50-year record of no easements of record, and which to us is dispositive on that issue.
Do you have a copy of the one that's before this?
Yeah, I have all of those with me. They actually go back to 1908, and there is a deed in 1908 that references a 2-rod easement, and then there's a series of deeds that go after that the 2-rod was dropped, and then it became more narrow, than it didn't state anything as far as the size, and then it was completely dropped in 1972, which shows an intent, in our opinion, of abandonment. And the reason for that, we've done a lot of research on that. There's a lot of easements around the turn of the century where deeds would include an easement, and 2-rod they're all over the place. Some of those were anticipated to become actual roads, and they did, and they matured into real roads. Others just died. They weren't used, and then they were abandoned. And so 50 years of nothing being in the deed is an indication of abandonment, but that's an issue of fact, and it's a complicated issue. I'm making it really simple. We would end up having expert witnesses, and we're hoping it doesn't go to trial, frankly, but we have to talk in those terms. And if it is found that there is an abandonment, then there will be no easement. There was some fences along both sides, the Packer property, and also that would limit the scope of the use. Now, the DeVores indicated in their written, and I have that here, and I'll show that to you, that the use was actually permissive. So that would account for you have a road, but it's permissive. I mean, if I live next to you and I tell you, walk across my property, you can do that. I can terminate that at any time. So it becomes fact intensive. It requires a judge or a jury to look at the facts and then determine, was there a use? Was it continuous? Was there an abandonment? That's a fact issue. And if was it a complete abandonment or a partial abandonment? All kinds of issues that's way beyond the scope of what you can handle.
But you're saying it was being used at the time, though? When you're saying it was abandoned, wasn't it being used?
I don't know. I mean,
I thought you just said it was. I thought you said they'd given permission for it to be used. It was
yeah,
being used.
there's permission to use it, correct. Now, whether or not it was abandoned before that, I don't know. Those become the issues for litigation.
So to your point you just made, you made a statement that there's a lot of this is way beyond the scope of what you can handle. What is the purpose in running us down a road of things that are outside of our scope? I'm trying to get to what is the capstone statement you're trying to get to from running us down the road of things that are outside our scope?
Well, that's a good question. The only reason I'm doing it has been an issue. And so I'm framing the issue as to how it appropriately can be resolved. Because the issue is, back on the statute, and I gave the standard, where it said easements of record. If it is of record, then it needs to be on the plat. If it is not of record, then it does not have to be on the plat. The challenge is we have a dispute. And there is a mechanism in the ordinance, and I'll get to that really quickly, on how the city is to determine whether or not it is of record. And the city has followed that standard and has determined that it is not of record. The city does not have to hire abstractors and attorneys to go and search the abstract to try to determine, because even then you can't tell. It depends on the facts. So I'm just trying to make it simple as to why it's not on the plat.
So, Mr. Smith, I appreciate your presentation. But you've come here, we've changed this zoning already. We've been thrilled about what Symphony is willing to invest in our community. We have a council that's educated. We have an attorney that educates us on this thing. I'm disappointed. I was hoping for a presentation about your project, and not about all these legalities. Yes, this is part of it. But are we ever going to get to the point where we discuss the project? Because you've gone to a lot of work and you made a nice project. So we'd like to hear that as well too. And I don't want this whole discussion and the public hearing to be all about this easement. We came to discuss many things. The easement's just part of it. So can we get to the project a little bit as well too?
Mayor, before we go to that, I do think that the project in essence has already been approved, and my main question is to our question of checking against the ordinance, right? And so my question for all involved, particularly our legal counsel, is what is the definition of proposed? Because when it's stated that a proposed easement should be included, then if it's proposed that this goes into a legal battle and may end up as an easement, we don't know yet, then should that be included?
Well, excuse me, you might be addressing that to
Well,
Ms.
I
Romney.
would be welcome, I'd welcome all opinions on that.
Okay.
But that's my pointed question, because that is what's in our scope.
Yeah, it's easements of record or proposed. Now, for instance, the plat has lots of proposed easements. They're not created yet. They're proposed by the developer. For instance, most plats they're going to have along the.
I understand what it usually means, but I'm wondering how broad that definition might go.
Well, it does not include what other people want to put on a subdivision. It doesn't include proposed. If you're doing a subdivision, I think, I want to propose that I put an easement on your property. It does not include proposed that way.
Well, that's what I'm wondering about if there's legal clarification, because in my mind, it could be said that it is proposed that this is a easement of record, and that's to be arbitrated through the courts. So Lisa, do you have an opinion on that?
Yeah, I think it's an interesting question. I don't really want to interrupt the presentation, but briefly, I think it's an interesting question because we've all been focusing on existing. So I would agree that proposed easements are generally the PUEs and the subdivisions, not someone that the neighbor wants or that's not currently existing. So in our mind, the question has been, are these requested easements existing? Whether they're record or clearly existing, but certainly the council can discuss and debate proposed easements as well.
So
I
where
think
you
it's more
brought
clearly under
proposed,
the,
it's brought
is
up
it
a new
existing?
question.
I think that's where we disagree, is whether these easements are existing. I'm not saying that they don't exist, but they haven't it's not, number one, the prescriptive easement hasn't been perfected, and number two, the easement appurtenant is not clear, given the record. It's not that we disagree or say they don't have one, it's just unclear. And so staff has taken the position that if it's not, generally we do have additional guidance in our ordinance that if it's not on the title report, that's the first place we look for existing.
And I know that this isn't yet the place for debate, but I'm clarifying what my question will be so that the discussion, the points made can speak to that. And that is that my question is to decipher if the appropriate easements are on the final plat. And the measurement for that for me is, has it been proposed? Is it a proposed easement or is it a easement of record? Both of those things are in question. The spirit and the intent of that ordinance existing, in my belief, is to service the purchasers of the land, the purchasers of the properties, so that they can be fully informed. And so if we are fully aware that this is going to go to be arbitrated in the courts, and we can fit it under the definition of proposed, then to serve the purpose and intent of the ordinance, I would consider that.
Okay, thank you.
Definitely put a pin in that one, because I want to come back to that after the public hearing, because I have similar questions on that.
Okay.
Well,
So-
Mayor, yes, go
So
ahead.
answer those questions and continue with your presentation, but for my sake, if there's other things we should know about the project, I'd like to hear about those as well, too.
Sure, thank you. And, I think your planner, he did a really good job at the basic elements. If there is no issue on the easement, that I was really retained to deal with that issue because that was the subject of the appeal. And that could be the subject of another appeal. And so we want to make sure that we give you enough information to make a good decision. So I hope you appreciate that. Unless the council tells me that we're not worried about it, it's not an issue, then I don't need to address it and I can sit down. But it is an issue. And Mr. Packer's here with his attorney and we have spent a lot of time on it. So I would appreciate if I could finish just so I can get the record clear
Sure.
on that. Thank you.
And I didn't mean to cut you off.
No.
When you said it was out of our scope, it immediately made me think, why are you telling me if I can't do anything about it? So that's why I was asking the clarifying question.
Sure, and my whole point is that, well, in fact, let me have you go, no, this isn't working. To slide number 24, if you would, please. For some reason this isn't working. And so this is the real issue then, is how do you determine if there's an easement of record? The court and you as the legislative body or your predecessors did not anticipate that the city attorney would have to be the judge and jury on that. And so there's an objective standard of how the city gets there Once the city gets there, then the issue is no longer an issue. And so here's what your attorney has followed, and it's in the ordinance, in 1503-030. The subdivider shall provide with the application, which Symphony did, a copy of a preliminary title report evidencing easements of record encumbering any property within the subdivision. So in other words, just like you do in many circumstances with engineers, you have your own engineer, but you also use professional engineers, and they do a lot of the work, and the city relies on that work. They're licensed. Abstractors are licensed. North American Title was retained by Symphony, and North American Title provided a preliminary title report. The preliminary title report, after they looked at it exhaustively, determined that there were no easements of record, and it's not on the preliminary title report. And so that gives you that threshold that, okay, those are not easements of record. And then the next section, and so that is in the preliminary section. This one is in the final plat section, 1504. Prior to recordation of the plat, so we're there now, the subdivider shall submit a current title report to be reviewed by the city attorney. And so it's the city attorney that gets the preliminary title report from the title company, reviews that, and that becomes an objective standard. If it's not in the title report by a title company, this is a multi-state title company, then it's not a record. And you don't have to worry about it beyond that. So it's not that complicated, to be candid with you. Are there questions on that, though? I mean, okay, if not, let me proceed. Okay, if you could go to, I'm gonna skip a fair amount here. I want to go to some, clarify some misconceptions that have taken place, and because they can sometimes become confusing, and if they become confusing, then it's hard to act. And so I want to make sure that we don't have those issues that are confusing us. The first issue I want to talk about is in an inaccurate claim number one. Mr. Packer or some others have claimed that Symphony breached the settlement agreement by failing to include the easements in the final plat. And I want to show just what really did take place. And here's what is written in an email that is part of the record that you have received. It says, "This, I believe, is an end run around the agreement to show on the plat the right-of-way I thought I had negotiated in exchange for my withdrawal of the preliminary plat appeal." Well, if you go to slide 27, this is the settlement that we put together, and I think it's relevant that you see that to make sure that, because this is kind of impugning the reputation of a really good company that operates within your city. So this was the agreement that was drafted by Mr. Packer's attorney, Matt Anderson, and it says, "We propose the following. We will suspend the appeal." That appeal had to do with the preliminary plat approval. If Symphony promises to revise the revised plat, and you notice that is capitalized because that was part of our negotiations back and forth by emails, to include the modified prescriptive easement pursuant to the terms and diagrams we've been discussing, the second revised plat. And it was in that process for the preliminary approval that a second revised plat was given that included that easement. And that's it. There was never any mention about the final plat. There's not any breach of that agreement here. If you look at number 2, Symphony agrees with the below terms, and then number 3 was the email that was sent to Ms. Romney from Mr. Anderson. "We have reached a settlement. Please suspend the Packers' appeal and continue the hearing." In other words, don't cancel it until, and then he says, "pending submission of the second revised plat set forth below, at which point the appeal will be officially withdrawn." Once that plat was filed, the appeal was withdrawn, and that settlement was satisfied. There was no further place to go. The next one, and I think this is really critical, is there's been some discussions that if that easement is not of record, that it will somehow hurt Mr. Packer's claim or his, if it ends up in a lawsuit. And I think that really is pretty critical. If you could go to the next slide, slide number 28. Mr. Packer's claim to an easement does not come from the plat. And this right here, number 28, if you look at what is in yellow, it shows the Symphony property, and then in green, Mr. Packer's property. So if you were to go to the county recorders right now, this is what you would see. And there's no right-of-way on the plat. It's not there. That doesn't mean he doesn't have a right-of-way. He can still pursue one, and that's going to come from the record to try to prove that there are easements of record, which we dispute. So it's not the plat that gives the easement. And so if the final plat is recorded and it doesn't have that easement on it, it doesn't eliminate his right-of-way. It's neutral. He claims the right-of-way. Now, there are lots of right-of-ways all around the city that are not on plats. That can sometimes be helpful if they're on the plat, but that is not dispositive. So what you decide today, there's nothing you can do that would either promote or hinder his right-of-way. That's going to be done in a court of law. And so it's not, and I just want to put your mind at ease that if there is an approval without that plat, it doesn't hurt his easement. If he has an easement, he still has the full opportunity to prove that. If he doesn't have an easement, the plat, if it's on the easement, still doesn't help. The plat is neutral to that issue.
Mayor, do you want us to wait till we're finished, or if we have a question for the applicant, would now be the appropriate time?
I think you should ask it.
So my question is, I understand your point that it wouldn't hurt the Packers' ability to continue to claim that they have a right. But how would it hurt those that have then bought the lots and or the homes? And so my question is a question of timing and the forecasted timing of the legal process versus the timing of moving forward and selling these lots.
And I think that is a really good question and a very serious question, and one that you should have concern about. The Planning Commission was very astute also, and they talked about that, and what we agreed to is we said, look, we'll take care of that. We will agree to give notice to each of those potential buyers so they can see it. And they'll know better than if it's on the plat, because really, how many people really look at a plat before they buy? I mean, if we were to take a poll, I bet it's less than 10%.
Symphony Homes was the one who agreed to give that notice?
Yes, it's right in the document. It's in the requirements for the approval. It's item number 2 or 3, and it says that you will give notice to all buyers that there's a claim of an easement, as long as there is a claim. And so let me go to a slide because I can show you that right now. This is a little hard to jump around, but if you go to number 33.
Is this on the 14 lots, Mr. Smith?
Yes, it is, or yes, Mayor. There are 63 lots in this subdivision. 14 of those lots are affected by the claim. And so that represents only 22% of the lots. And this slide here, you can see that is called a lot fit exhibit. This is what Symphony will be giving as an attachment, an exhibit to every contract of everyone who buys in those 14 lots. Certainly it's not going to go to the other lots because they would not be affected. But if you look on that, it shows, and it says area of purported easement as described in notice of claim. The notice of claim is on the plat, and the notice of claim describes very well, and that's pretty technical, certainly. But this gives a summary of that, and then it shows the homes. They have actually put together a footprint to show how the homes are going to fit on the lots and how they comply with your ordinance. And so every single lot fully complies with the home placed on the lot with that claim. Now, it's really important to understand what the easement is. Again, it's disputed. We don't know if there's going to be. We claim not. They claim so. That won't be determined here. But this will be given to the buyers. The buyers will be aware of it. Not all buyers need huge lots. There's a serious market for smaller lots. But the easement is a surface right to travel against if he is able to perfect it, if the court agrees with his position. It is not ownership. It will never be ownership. It will never mature to where Mr. Packer will own that 33-foot strip. It would only be a right to travel across it. And so there's an issue whether or not it will even survive, or if so, how wide. And then usually another issue is the scope of the right of use. Because again, Packer won't own the easement, is what is his right. And it's going to be limited to what the court will find certainly, but usually it's the historical use that he has used it. So it's going to be a farm access. And so the homeowners will be able to use the property. They'll have title to the property. And this has gone through planning staff. It doesn't affect easements or water issues or any of the other
And the
issues.
lots and the building, where the building is situated, everything would still comply?
Yes.
How can it? That other lot, the setback, I mean, basically that easement runs right up against the back of the house. How can it possibly comply at that
The
point?
setback is not to an easement. The setback is to the lot line. So you can have a 10-foot setback and have an easement within that setback. It's setback, your ordinance doesn't go from the end of the easement forward, it just goes to the back of the lot. So it doesn't affect the setback at all.
But if there's an easement, wouldn't there have to be to the point that he could drive his farm equipment down that easement through
Yeah,
those
so it would
people's backyards?
possibly influence the ability to build fences.
Or any
improve
type
or
of
do
building,
anything.
garden, or a barn? I mean, if
Yeah,
they've
that-
even got grass, if
But
he's
if
driving
notice
through
is
it.
given, and that's explained, and so we'll ask later clarification of what notice given means, right? And to make sure there's an understanding there, but.
And that's an issue of use, and that's a really good question, but it determines on the size of the easement and the scope of the easement, which will be determined if there is an easement. But let's go to the worst case scenario for Symphony and the best case for Packer. The court finds there's a 33-foot easement. Then he'll have full use of 33 feet. And it would not be appropriate for anyone to block his access. The law on what can be done to impede is really well developed. So we don't have to question about that. He would have full use. The easement, if it comes to fruition, again, we say it won't, but if it does, it'll be a non-exclusive easement, which means that he could use it, and so could the other property owners. Symphony owns the land. They could give the other property owners access, and it could become access or subdivisions that are designed this way, where they have a back access so that people can drive to the back, get their truck, park their boat, those kinds of things. So there's a marketing aspect that's very positive to this. Any other questions? Very good questions. Right. Well, there's one last part that I wanted to, and I'm not going to show the slides. I've spent some time in your questions. There's been an issue of that Symphony is trying to take away the access, and that couldn't be further from the truth. I was actually retained not to litigate the issue, but to settle, because that's kind of my specialty. And we have met several times and made proposals of outcomes that far exceeds anything that could be obtained in court. So far, they have not been accepted, but there have been iterations. There's 4 or 5 major offers that have been made to settle, and many iterations of some of those within a certain category. Some that would result in Mr. Packer actually getting land. There was, the very beginning was an opportunity for Mr. Packer to actually develop with the project. He chose not to, which is fine. There's no animosities with us and Packer. I mean, he's a good man. We just have a misunderstanding. And I suppose once we get this approved, we'll spend some more time with Mr. Packer and see if we can come up with a win-win solution. That's what we really do want, and so does he. So the chance of it going to court, I don't know. But here's what I do know, that Symphony has satisfied all of the requirements, all of them. And in the administrative, if there's a motion to not approve it, there's got to be an ordinance that goes along with that is in violation, and we need to know what it is so we can correct it. But if it does apply, then really the appropriate action would be to approve it as it is. Do you have any other questions for me?
I have one for you.
Yes, please.
That email you showed us from Mr. Packer's attorney, Matt Anderson.
Yes.
If they're going to the effort of giving up their rights to go to our city board and you consent and say, yes, we'll put it on the preliminary plat, just because they don't state in their email, wouldn't the reasonable man's assumption be that they probably would like to see that on any plat going forward?
Oh, I think that I think that's reasonable that they would like to see it, but we actually had discussed that. If you could go back to slide number 27, we discussed, this email was the result of probably 2 weeks of pretty intense negotiation. I don't want you to think it just happened. And there were all kinds of permutations back and forth, but here's what it came down to. That language was drafted by us talking, because when I answered on, if you look at the second item where I put, Symphony agrees with the below terms, just because we had negotiated every single word. And so when you look at this, in the fourth line down, if you can see, you probably can't read that, it says, as we discussed, both sides reserve all rights, claims, defenses, etc. for litigation. We wanted to say, well, let's just do this, let's put it on for everything, and let's have no appeals, but that didn't take place. Mr. Packer wanted the opportunity to come and present an opposing view, which is his right, and we support that, and also to appeal. It doesn't stop him from appealing either. And so it certainly wouldn't be that we would say, okay, we're going to put the easements on. And to be real honest, let me be really candid with you. The prescriptive easement, that's a problem, because that takes another entire lot. That's a $250,000 issue, and it's based on what, a claim. There's nothing of record, there's no potential argument. But the other issue, we're going to be disclosing this to buyers anyway. If it's on the plat or off the plat, it's not a big deal for us, to be really perfectly honest with you. There's a reason why we agreed to it, because we had a notation on the preliminary plat that this is in dispute, and we reserve the right, because this is what's interesting, and you need to understand this about plats. Plats can convey easements, and so we couldn't put it on the plat and not have a reservation of rights to say that the fact it's on there is shown illustratively, but it's in dispute. As long as that is saying that it's in dispute, then we haven't lost really anything, because we're going to be disclosing. I showed to you what, if you go again back to slide 33, that's what the buyers are.
Before we go backwards, Mayor, I will say that here, it's very clear that this was very deliberate language, and this is proposed and submitted by Packer's attorney. So,
Yes, I see that,
yeah,
yeah.
yeah. And the attorney is the one who would understand that this is very specific and targeted.
But so if you say it doesn't matter to you, are you willing to go ahead and put it on the plat? You just said it didn't matter whether it was on the plat or not. You guys didn't really care. So are you okay with it on the plat?
Let me show you one, and we've had some discussion about this. If you go to slide number 35. Well, before I do that, let me give you one piece of background. Go to slide 29. I'm going to spare you I have the deeds here that on the prior deeds. The prior deeds in the meets and bounds, you've read those. The deed goes on the Packer property, the predecessors, clear back to the 1908 deed. It goes to the Bamberger rail line, okay? So it stops at the Bamberger rail line, then comes around the rail line, and then comes back, and all the deeds have that call in it in Mr. Packer's back title. Any language that was 110 years ago that was purporting to create an easement Now, we're claiming that they've been abandoned, but it also runs along that same line. And so if you look at number 29, you can see that yellow portion is what could be claimed as an easement of record. We claim it's been abandoned, they claim it hasn't. That's the litigation issue. But that black line is the Bamberger rail alignment. But it doesn't get Mr. Packer to the far west of his property. Because if you look at it, there's lot 120 and 121, you can't see that, but west of that line, there's another line, and then you have the 400 West Road that you probably recognize. So that only gets Mr. Packer over to Main Street, but it doesn't get him over to the other unless, and that's where the claim for a prescriptive easement based on use, that we've put that one to bed. So here's what was proposed by, well, at least in the appeal, if you go to number 35, this was the exhibit that was attached to the appeal by Mr. Anderson. And if you look at that, that crosshatch red line, it actually goes all the way over to lot 120. I think it's a different number now, but it's really 120, and it actually goes beyond and through the Bamberger, which there really is not a claim there. We don't see how there could even be an argument there. But this is what we put on the plat, because it does at least show to some degree that it goes to that road, and we would be willing to do that, because that would show that if there is any kind of prescriptive, which we're really confident there isn't, but it at least gets him to the road. There will be the language on the plat very similar to what was on the prelim, saying that it's in dispute, or otherwise it would be a conveyance of an easement, and that we won't do. But to put it on for disclosure purposes, it doesn't bother us. We're going to be giving that information to the buyers anyway, and then it's going to be resolved hopefully by negotiation, and then would be eliminated. If not, then through litigation. And then at the time that it is adjudicated, then we will amend the plat to conform to what a judge says. So the buyers will be notified, with or without on the plat. Mr. Packer's rights claim to easements, whether it's on or off the plat, will remain the same because he's not claiming rights to a plat. The easement, if we put it on, will have the same language as the preliminary plat language, although it has to be adapted from preliminary to final plat. We'll still put it in issue so that we're not going to be going and facing a judge saying we gave it up. So I don't think we're opposed to that. And if Mr. Packer's attorney will be able to address this panel, is if that helps them not to file an appeal and save some hassle for the city and for us, then it's worth it to us, frankly.
Thanks, Mr.
That was a
Smith.
very good question, Ms. Wilmore, thank you.
You done?
I'm done,
what
and,
you're saying?
as long as you're done. If there's any questions, yes, I am done, thank you.
Council may have some questions, but if I know my council, they might want to hear from the public as well now too. But council, I don't want to speak for you, so anything else for Mr. Smith right now?
No.
Okay,
Thank you so much for your patience, I realize that was a little lengthy.
thanks. So between Mr. Smith, Representative Symphony, and Corey talking about the city, Corey talked a little bit more about the project besides just the easement. Hopefully we have some background to now open this up to the public for a
I'm so sorry, before we do that, I just want to make sure I heard you right. You said that you would feel comfortable with showing that generous length of easement on the final plat with a note that it's disputed.
Yes. Just as I showed it to you,
Oh,
which was attached to the Packer appeal.
okay, thank you.
Thank you,
Thank you.
Mr. Smith and Councilwoman Fillmore. So this is the public hearing on the Summerhill Lane PDO, the final subdivision plat. For those that may have commented or watching online, it is on your screen, and I will monitor with our city recorder is if there is anybody waiting to speak. For those of you that are come in online or come in on person to this, please identify yourself, your name, and where you're from. So we now will open up that public hearing.
Thank you, Mayor. For the record, my name's Spencer Packer. I reside at 581 Valley Drive and have been a citizen here for 38 years. Thank you for allowing me to speak, and thank you for your service as elected officials. I also prepared a slideshow, and with that, I would like to request to be able to show that as well as take more than the required or asked for 2-minute length.
Well, generally, public hearing, we don't have to stay to 2 to 3 minutes. I mean, we want to make sure that you get your presentation in, so.
Oh, thank you. I will attempt to be brief, so thank you. Again, I do not oppose the fact that Symphony is developing the property next to me. That is their right. What I do oppose is what I feel is an attempt to take my personal property rights, which is my access, my only access to the property. Jennifer, thank you for your help this evening. So I'm interested in a good quality subdivision development, I think, as everyone is. Again, I'm not opposed to the development, but I do wish to preserve my personal property rights. Next slide. This is an aerial view showing where the property is and my property in relation to it. Next slide, please. This is a overlay showing the Symphony proposed development as it relates to my property as well. And it also shows that right-of-way that Symphony is disputing that I have. Next slide, please. Jump ahead one more. There you go, thank you. So back in 1908, Hiram and Mary Drake sold the west half of the property that I have to Bernie Halliday, and in the process of selling that, created an easement access to that property. The Drakes created it, thereby it was named Drake Lane. Next slide, please. This is the warranty deed from 1908, and we'll just focus in on the next slide where we pull in a little tighter. Just to read that, it says, it gives metes and bounds, but it says, together with a perpetual right-of-way for general purposes over and through a certain 2-rod, sorry, I need to get closer. I'll speak loud.
She's got a microphone for you, Spencer.
Over and through a certain 2-rod lane running west from Davis County Highway number 1, which is Main Street now, to and abounding the said, it's in cursive, said plat of land.
Tract of land. There you go.
Thank you. On the south, and also the right to convey water to said land for irrigation purposes through and along said lane by ditch or other means. So what that tells us, it's a perpetual right-of-way. Webster says perpetual, it says it's never ending or changing by definition. It's appurtenant, it's attached to the parcel of ground. It's for general purposes, which is as broad a right-of-way as granted under the law. And it's 2-rod wide, defined as 33 feet. I'm certain that Symphony wishes that 1908 deed did not exist, but it does, and it supersedes or overrides all of the other deeds that follow because it's attached to the property. I have several other deeds showing other right-of-way, but if we could just drop to the last one, Jennifer. Just scroll through on conclusion, if you would. So the conclusion is, I don't oppose that they're developing the property. My notice of interest does constitute an easement of record. Within that easement of record is all of the deeds that from 1890-something, all the way forward. It formulated the Drake Lane, and that serves the Packer property, and an important issue that it has never been extinguished. With that, I thank you for your service and the time you've allotted me.
Thank you, Mr. Packer. Further? Come on, go ahead, just introduce yourself, where you're from.
Thank you. Matthew Anderson, I'm attorney for the Packers. I live on 98 Bear Creek, Kaysville, Utah. That leads me to my apology. I live about 2 blocks away from where Jennifer lives, or 3, or where she grew up anyway. And I've communicated with her via email a couple of times, and I apologize for not recognizing that we know each other, but.
I didn't recognize it there until you
Yeah,
walked in.
okay, so it's
We're okay.
not just an age thing, it's just we didn't have the face-to-face. So anyway, and I'll just tell you, I have spent maybe a decade or more as a member of the Kaysville Planning Commission, so I have a little sense of what you go through on these nights, and most of the time I've spent on the other side, just going through these just sometimes horrendously long hearings, and so I want to thank you for that, and also acknowledge that I'm about to contribute to that. But I do think your service is valuable, and obviously as the city council you have a little more weight and a little more difficulty in it than the planning commission, so I want to express my appreciation for that. So the objective for the Packers tonight is to get these easements on the plat. And we have been fighting about this with the Symphony Home since the very beginning. And for them to say today that they'll put on the Drake Lane easement on the plat with the note, if that's really going to happen, then I'm going to cut my presentation in half. And so that's maybe a little incentive to clarify that. I appreciate what the council members have done to try to get that clarified. It sounds like that's what they're willing to do. And so if you tell me that's what's going to happen, then we'll talk about, we won't talk about the Drake Lane easement.
We don't know what's gonna happen, that's.
Well, it's a condition, right? I mean, the city council here has a chance to say, we will approve if this is done, and it sounds like they've agreed to having it done. And so if that's where things are, then great, we'll move on. If not, then I'll discuss it and we'll cover it, that's fine with me.
But even your proposal to discuss the Drake Lane easement puts us in the position of adjudicator, which is not our position tonight.
Correct.
I disagree. Maybe I misheard you, but
My understanding, it is not our position to determine whether or not that easement is valid. That will be determined in a court of law, so.
It's not
No,
asking
it's
us
just
to do
whether
that.
to put it on the,
it's not.
And they agreed
Yeah,
to
he's
put it
just-
on, and
he's
he's
just
just saying
put
if
it
they're
on
gonna
these-
put it on, then he's okay.
Right, but it sounded to me like he was going to give us detail about the history and the existence.
He's
think he
saying
was,
he
but
doesn't
he's
need to
saying
do
if
that
they
if they're
stipulate it,
willing
he
to put
doesn't
it
care.
on there.
Yeah, but
Regardless, he doesn't need to.
I'm where you're at, Tammy, on this, in terms of, I'd say stay tuned. There's a whole public hearing we have to get through. I'm not making any obligation to any party at this point. Let's get through the public hearing.
That's fine.
And then frankly, I'm going to signal already that I think there is legal advice and counsel that we need in a closed meeting, because there are questions I want to ask that's going to disadvantage everybody in the room. And I would prefer to do that with the confidence of being known that that legal advice is being given in the right venue to us, rather than trying to debate the merits of what we're thinking
Yeah, so
against the
it's
legal
pretty
process.
safe to say we're going to table
I think we're going to be doing that. So I would say, don't ask us for that kind of obligation. If you feel you need to talk about it, great, but again, where Councilwoman Fillmore's at, if these things are outside of my scope, which your peer is telling me they're outside
They're
of
on
my
our
scope,
scope, so.
we're pretty clear on our scope. We've been doing this for a while, so yeah, I'm okay to have it be duly noted that there is disputing documents and then move forward.
So, to be clear, I disagree with my peer on almost every one of these points.
You wouldn't be an attorney if you didn't, so that's fine.
I mean, but that's why we're here. It's not because we're attorneys, it's because we have a point of view that we think is not being recognized.
What I'm
And I'll say-
asking is for the comments to stay very targeted on our ordinance.
And I'm ready to talk about that right now. So your responsibility here is to make sure that the final plat complies with the code and with the city requirements.
Yes.
Okay. So in that, the code says, in one place, it says whether it is existing, and as you mentioned, whether it's proposed. So that's one question you have to answer. But the other question that's been, I would say, glossed over is in preliminary plat approval, there's a condition that says the final plat, it's not the preliminary plat, the final plat shall comply with subsection L that has to do with with preliminary plats. And that says this final, the plat must show easements of record or claimed by usage. So let me state that again, because that's very important. At preliminary plat, where there was no depiction of easements, the Planning Commission said, final plat shall comply with subsection L of the preliminary plat language. So it says, in other words, in order for final plat to be approved, it has to comply with L, which is of the preliminary plat, which requires easements of record or claimed by usage to be depicted.
Easements
Not.
of record or what?
Or claimed by usage. Easements claimed by usage. So we have an easement of record. It's been recorded multiple times over the past 100 years. It's a pertinent easement, which means it runs with the land. That means by Utah law, it doesn't have to be conveyed each time a deed is conveyed because it stays with the land. It's made so that people who have land and have access and need access to it, keep it. Okay, so we have an easement here, the Drake Lane easement, which is an easement of record. There's no disputing that. It's in the title report. The title report sets out that there's a notice of interest. In that notice of interest, it sets forth the recordings, the multiple recordings of that easement. Okay, it doesn't say here is an easement. It says there's a notice of interest which refers to the easement. And let's just talk a little bit about what title insurance companies do. That where it shows up on the title report is a list of exceptions, meaning things that are outside of title coverage. So if you buy that property, this is not covered by title insurance. And so what Symphony Homes has done through their title company, and Symphony Homes is a big client of this title company, they have made it so it doesn't appear to be an easement. It's a notice of interest. Now that's what we recorded because that's what the law, that's the category under which it falls. But it is an easement and it is of record and it hasn't gone away. It's not been extinguished. It's extinguished by a writing or a recording. So there is an easement of record. There's also an easement.
Can I ask one question?
Sure.
there? So was it a notice of interest or an easement of record on the preliminary plat?
On the revised preliminary plat or original?
Yes, the one where you waived your rights to go to a board.
Yeah.
What was showing on that easement?
So that showed
Or on that plat?
that depicted the full easement like with the
Okay.
shaded lines that we
Just
saw.
wanted to clarify.
And just to address that question about the settlement, we were under the understanding that the final plat had to comply with the preliminary plat code because that's what condition 9 says. And so when we agreed to something being on the preliminary plat, and because the code required it, we also expected that it would be on final plat. So yes, the language doesn't specifically say it's on final plat, but we had a condition by the city that said that the final plat had to comply with the preliminary plat rules. So we thought we were locked into a final plat with the easements showing. Okay, so we've talked about an easement of record. Utah law says it doesn't have to be conveyed. It doesn't get lost if it's not conveyed. The easement's been in existence for a long time, for 100+ years. The Packers have been using it for more than 20 years. Same with the prescriptive easement, but the prescriptive easement is not of record, and that's the way it goes with prescriptive easements. They're not of record. So that's why that's why the code says an easement of record or claimed by usage. So we have a condition of final plat that it be compliant with subsection L, which is the preliminary plat and claimed by usage and easement. The other thing is that we have in final plat code, it says it must be existing easements must be showed or proposed easements. I thought your reading of it was very interesting and expansive, and I don't think there's anything that says that's not a correct reading, that a proposed easement doesn't have to be proposed by the developer only, it can be proposed by, or suggested, or indicated by others. But certainly, this is a prescriptive easement, and as soon as, Utah law states that as soon as that person has reached 20 years, the easement is in place, and it's existing. To say that it's not existing, just because it's not recorded, makes that extra language in that code superfluous. Because if you're only gonna go by what's in the record, then or claimed by usage is meaningless. Okay, so there has to be a reason why it's claimed by usage, is the language in there. And then you also have to look back. If you read both these statutes, and I had planned here to read them both, and I shouldn't say statutes, I should say codes, but I'm not gonna read them. But if you look at those, the one that's for preliminary plat and for final plat, it's very specific about how an easement must be recorded, it must be depicted, and the outlines, the boundaries must be shown. Why is that? It's because people need to know what they're buying. And if you put a title report in front of a buyer that says, notice of interest, hand them a half-inch thick document to interpret it, maybe that's not a half-inch, they're not gonna understand what's happening. And Symphony Homes is here saying today, for the first time, that they'll put it on the final plat. So that's why I want to take them up on the offer, not only because it saves us time tonight, but that's what we're after. As I said, we want to have these two easements shown on the final plat. And why not show them? If condition 9 requires them to be on, if the code requires them to be on, and it's arguably good governance and protecting your citizens, why not have them on? Why not have the easements depicted on the plat? And we can ask Symphony Homes, why not put it on there? Why didn't they put it on at the very beginning? They knew about these easements. They knew there was an easement claimed by usage, and they knew there was an easement of record. So that's a good question, but I think we have to decide, when I say we, I mean you, have to decide would you rather err on the side of full disclosure, making so the citizens who buy this property can look to the city and say, oh, the city made sure that this was on there? Or would you rather err on the side of allowing the easements and the effects of the easement to be discounted, hidden, covered in a notice of interest that doesn't give adequate notice? So we have an instance where we're going to have, the potential here is there's 14 lots, and the backyard of it is going to be eaten up by some guy driving his tractor and his trailer and his horses up and down that road. And I don't know how that turns out, but I can imagine it's going to be difficult. I have a lot of little kids at my house, and to think about them putting them in the backyard with an easement running down through that doesn't seem like a good idea. Now, maybe the council can decide what kind of protections can be put in place so that kids don't get hurt, so that the access is maintained, so there's not a lot of fights and there's not 14 lawsuits and there's not a lot of chances for the city to get involved for not having complied with the statute that required easements to be shown. What's the purpose of not having that in there? Why would we err on the side of not letting people know what's happening or what the risk is, right? We're talking about a risk. I'm here to tell you that we're going to win in court, but council thinks opposite, right? So I'm not asking you to decide who's going to win in court. The question here is, did the code contemplate or require this full disclosure? And is there anything wrong? Is there any downside of full disclosure? If a citizen looks at this process and sees that the city did not require the easements to be shown, and then they look in their backyard and see what's happening, are they going to be upset? Are they going to feel like the city protected them? I don't think so. And certainly my client doesn't think that he's being protected by the city. But that's not really the point here. The point here is if these easements are shown, both the prescriptive and the Drake Lane easement, then we're okay. And that is that's not going to solve all of our problems, right? We're going to continue with other stuff, but it's not going to involve the city. This is what we want of the city, and this is what I opened up with, and this is what I'll close with. We think the city should do some planning and some governing and use its discretion and have Symphony Homes address this incompatible use or seemingly incompatible use. We think that should happen. But what we want tonight is to make sure that the final plat shows, the preliminary plat, shows both easements. Because one, it's required by code, it's an existing easement. Two, because it's a condition 9, and 3, because it's good governance. That's the end of my prepared comments. I have a lot of answers to some of these questions, and if you'll give me a few more minutes, I'll try to quickly address them. But that's, if you have questions that you'd like to ask, I'll do that. Otherwise, I'll go through my short list and then I'll be done. Any questions? Okay. Well, I think I've covered it. I think I've answered the questions and responded to some of the things that I felt needed correction from Symphony's position. But I'm happy to answer any further questions, comments.
Thank you, Mr. Chairman.
Okay, thank you very much. Appreciate your time.
Thank you. So we've heard from the Symphony, we've heard from the Packers. We're welcome to hear from anyone else, either on this issue or on anything else about the final plat. Come on up, introduce yourself, where you're from for the record.
Thank you, Mayor. Andy Babelis, lives in Centerville. I think I have one of the oldest owned properties in the city. And we've learned by experience that going back on records is really essential, especially for easements and all that. I also have some property up north that we had to have the same particular problem. The reason why I'm here is that fact that they're talking about right now is really for our protection and your protection too. As you review this, I think, honestly, Mayor, there's a win-win situation here if it can be worked out just right, because it can be very complicated. The property that I got up north, I purchased from the church, and we had to go way back to the history and the plat and layout, and it took some time. Finally, when we settled it, we finally did. But if you can do a win-win situation for Mr. Packer and for Symphony Home, that would be good, because this could drag on, and he's right, the fellow who spoke before, by listing that and defining the situation, protecting yourself and him. I think people could be very happy over this. I know I would, Mayor, over my property, and I have 2 or 3 of them, and we've had to work with those easements too. And the only thing I want to else say is this is a very good city council and a good mayor.
Thank you. Thank you, Mr. Bells. Further?
All right, my name is Trent Packer. I live up in the Rolling Hills area up there, and I am Spencer Packer's son. I have no ownership in the property. I'll keep it under sub 2 minutes because it is 8:50, and part of me wonders why the elected officials have signed up and volunteered for this job, because it's running on late. But I guess it's better than a gripping episode of Law and Order. So this would be great if we could resolve it. I've been in a lot of the meetings with Symphony. I've been in a lot of meetings with the attorney and gone over the facts. I'll just let you know our intentions, and that is to have something that's right and true. And I just want to let you know that that's really our intention, is not be malicious. And thank you for hearing this about this big concern, because as you pointed out, Mayor, tonight Symphony has had to spend all their time and energy and effort to talk about this issue. You can tell they spent money on slides They depicted it one way or the other, and that's really not what our intent is, but we're glad that it is being brought in front of you. So we hope that it does get shown on the final plat, and that it also gets shown on the final plat without any additional language that it's hotly contested or disputed. Thank you.
Thank you. Further comments from the public? Just remember to identify yourself.
My name is Kirk Fowers, so I'm a Centerville resident. I live at 2144 North, 400 West. And so my property is adjacent to the Summerhill Lane subdivision. I'm also adjacent to the remnant property that's there. So there were initially 2 remnant properties, one that's now been incorporated into Lot 148, and the other that's still listed as Parcel C. When all this process began, there was a lot of neighbors that came together, and they came and they talked to the Planning Commission, they talked to the City Council, and Symphony participated in all of that. And the goal there was to address some concerns of the residents, but also to address concerns about people who aren't here yet, ones that eventually are going to be purchasing these homes that are part of the Summerhill subdivision. So I'd like Symphony Homes and the Centerville City Council and Mayor Wilkinson to consider those things and consider those individuals who are not here yet but will be impacted by the decisions that you make. There are 4 parties that are impacted by those remnant properties. Symphony Homes is impacted by it, the city is impacted by it, the future HOA is impacted by it, and so is our family. And so each of us have a bias related to that. And for us, the bias is it's adjacent to our property. There's some things that we'd like to see, and that would be our preference, and there's the same with each of the different groups that are here tonight. The piece that's been incorporated into Lot 148, that's something we approached Symphony about 8 years ago when we offered to purchase that property from them. At the time, they said, we haven't done the development yet, don't know what it's going to look like, so they declined us purchasing that property, and that's fine. Understand that. As we've moved forward, we've offered 3 different times to purchase that piece of property. At one point, they said you could purchase that, and then they said, no, we don't want you to purchase just that. We also want you to purchase Parcel C. Well, that piece on Lot 148 makes a nice backyard for us. That's our preference. It would be a rectangular backyard. It would square things up a little different than the L-shaped yard we have now. That would be nice. When you look at the other piece, that Parcel C that's on the north end, it's on a corner, it's rounded. There's not a lot of use for that. It turns us into a corner lot. That isn't, you'll hear different descriptions of that it, it makes a buffer between us and the road. It makes a, transition into the neighborhood. When you look at it, it's a corner lot. It's not something we would really like. But that's something that Symphony has said, well, we would like to, that's what we'd like, is you to buy both pieces of those property. And that's certainly within their right to request that. But as we look at Symphony's bias, their bias, they're a business. They're there to make a profit. They also create wonderful neighborhoods, one of which I live in. And I enjoy living there. And I think people who enjoy living in the Summerhill Lane subdivision as well. That's their bias. From the city side, you'd like to have, and that's what's in the city code. I've heard a lot about city code. I don't have a PowerPoint. No, I'm sure that won't upset anybody. I don't have a PowerPoint. It's been a long day. But as we look at the code in 15.05.020 on lots, number 7, it says, remnants of property shall not be left in the subdivision which does not conform to the lot requirements or are not required or suitable for common open space, private utility, public purpose, or other purpose approved by the city council. So this question is up to you. When it was initially presented to the Planning Commission and also to the City Council back in April of this year, what it also noted from the staff was the applicant shall resolve the remnant issue located at the intersection of 400 West and the new roadway with the priority of transferring or incorporating the land area into adjacent lots. They've done that with one piece. They've taken the piece that we would like and incorporated it into Lot 148. And that's not something we've been allowed to purchase on its own. So what we've approached Symphony with is another offer is to say, look, we're happy to purchase that piece of property. We'll incorporate Parcel C. The piece on Lot 148 is 2,150 square feet. The piece that's Parcel C is 3,419. It's reasonable for us to purchase something that's 40% that fits in our yard. It's not particularly reasonable for us to purchase something, pay for 60% of something that doesn't really fit. So that's our bias. Now, as we think about the homeowners association and their costs and what the maintenance will be going forward, That's one of the things, we were in a homeowners association when we bought the home, it's Lexington Park, it was something that somebody set up, that's now defunct. So I never paid a due, I never paid any money towards that, it just disappeared. The city, I think, took over the drainage, and they now maintain that, that's on the frontage road. So I called up someone who's in the Woods Park in that homeowners association and asked them about their experience of having a homeowners association. Now, Symphony has proposed that they have a neighborhood monument that'll be on that property. Now, there's some limitations because it's a corner, you can't visually impede, going around there, so they could put something there, which is fine. The Woods Park has 2 monuments going in that specify the subdivision. It's probably on 500 square feet. This is 3,419 square feet. That's quite a monument if you fill the whole space, but most of it goes and wraps around. So I'm still unclear exactly what the public purpose is, and that's one of the questions we want to ask you. The other piece is from the homeowners association. They've expressed some frustration because as a homeowners association, you have some understanding of what you're getting into. But in the Woods Park, they had a small strip that's a park. Well, it wasn't appropriately developed. It flooded. There was a very tiny play area that was set up there. You couldn't put a play area in this corner. That wouldn't be sensible to put kids in that space. It was for ages 2 to 5. So they were not really thrilled with that. As they looked at potential options, the city doesn't allow them to change their HOA. The people who will be part of the HOA, the people who will run the HOA for decades to come after they live in these homes, has no say in the public purpose of that piece of property. That's why it's important for us, the ones that are involved now, us and Symphony and you, it would be nice if we could come to a reasonable accommodation. We would take that piece of property, we would maintain it, we would meet the needs of the city to make sure that's well maintained. We have a very well maintained yard. My wife does an amazing job. We would have concerns if it was an HOA. It's not something that benefits the homeowners. What benefit do they have to have that space? What are they going to do when water becomes less? Do they have to change the landscaping again? Do they have to do different things? What are they going to do? And what would we do if they don't maintain it properly? That puts us in an awkward position. They have that large piece of property next to us where we have no say over it, but I also don't feel like we should have to pay for that to then turn around and maintain it for the benefit of others. That creates 250 extra feet of sidewalk. There's not too many homes I know of that would have 350 feet of sidewalk and mowing or whatever else is incorporated into that. So I just want the city to consider those things as they're looking at this piece of remnant property, consider the code, and my hope is that Symphony and us come to an agreement where we can incorporate that into a home that's reasonable for all of us. We're willing to pay for the piece that we've always wanted. It's important to us. It would be nice to have. It's really tough, to pay for something that benefits the other 3 parties to a large extent and is maintenance cost and challenges for us. So I appreciate your time, and I also appreciate your service. And Mayor Wilkinson, I know this is in your purview, but as things come up, if there's questions or things that come after it, I appreciate the opportunity to respond to some of those if they come up later in the discussion. Thank you.
Thank you, Mr. Fowler. Anybody, we have more people from the public?
Hi, my name is Matthew Cutler. I live on 2177 North Main Street. I am here because of an article from The Economist in 2005, and I'll get to that in just a second. More importantly, I'm the coach of the Viewmont's high school speech and debate team. So I help them learn more about argumentation, and I wanted to comment a little bit about the argumentation that I've been hearing today. First of all, what I have gained from this is really a whole lot of nothing. It's been a whole lot of framework debate, and it's been a whole lot of definitions debate, which really benefits nobody, right? When we talk about framework and we talk about definitions, we can get into the nitty-gritty, but that means nothing in the course and action of the daily lives of citizens of Centerville City, right? And citizens of the world. What I want to talk to you guys a little bit about is impact calculus. Impact calculus is something that I do with my students to teach them a little bit more about what their arguments mean and how their arguments can take shape in the world around them. Impact calculus depends on three things. They depend on probability, on severity, and on time frame, right? So we talk about the impacts of what we are actually talking about. From what I see, if the Centerville City is to require that full disclosure happens, right, and full disclosure happens on the plat, that there really is going to be a benefit to people that are coming in to the community and people that are already in the community. If we are not requiring that full disclosure happens, there is a negative impact that is happening there. So let's talk about not requiring the full disclosure. And really, I want to talk about the impact as it is to quality of life. And this is where we get to The Economist in 2005. They define quality of life by 9 variables. The 9 factors are material well-being, health, political stability and security, family life, community life, climate and geography, job security, political freedom, and gender equality. And I really want to focus on community life because this is where y'all have the biggest impact, is in the community life. The probability of a negative impact to community life is very, very high if y'all don't require that full disclosure happens, right? We have seen that this body has been burned before by developers, severely. We just heard about Woods Park. Woods Park was terrible, right? What happened in that community is devastating, and I don't want to see that happen again. Another example, across the freeway, right? We thought that we were getting a retirement home, and now we have condos. Like, they're not the same thing, right? So we obviously know that we cannot trust the words of a developer. The time frame of this happening, I would argue, is as soon as construction happens. And the severity of the impact that you're going to see is you are going to see a negative impact not only to the Packers, but everybody in the community around them, because we are all a community, we interact as a community. And the impact that you're going to see is you're going to essentially halt the self-actualization of everybody here, right? Because you're not allowing us to have our own personal freedom to move, to act, to access our land, right? We're all going to see this body in a negative manner because y'all are not allowing us our rights to our property. On the flip side, if we are talking about requiring full disclosure, requiring that there have that easement, you're going to see your only negative impact that you're going to see is a delay in economic impact, essentially. We know that there is going to be development that happens. True or false? True. Corey has never met a development that he doesn't like. And we continue to develop all of the property here in Centerville. That's a fact, right? You're just going to delay until we can actually litigate and have a judicial body decide on the easement. And from there, you're going to see a good impact on your quality of life of your citizens, right? The probability is let the courts decide, right? Let the courts do what they need to do and make a decision so that you can then fully make a better decision in the future. And the time frame is the time frame of the courts, but the impact, the severity, is the self-actualization of all those involved, right? You are letting the Packers self-actualize. You are letting the community around the Packers self-actualize. And that is so important as your body, right? We elect you to help us gain that self-actualization. And without that, you know, if you're not doing what we elected you to do, that, I mean, what's the point of this body, right? So it's for those reasons that I think that you should require full disclosure. Thank you.
Thank you, Mr. Cutler. Anyone else from the public? Do you have anybody online? Jennifer, is there anybody online?
My name is Ivan Cutler. I live at 235 West, 2150 North, just adjacent to Spence Packers property. There's a word that I've come to love, and that's the word reminder. And sometimes I think we need reminding of why we're here. And it's the duty of any elected official to represent the best interests of its citizens. And one of those citizens is Spence Packer. There are many here that are in support of Spence Packer because they've been directly impacted by the great love he has not only for this community, but for the individuals that reside here in this community, as well as the Fowers family. They're directly impacted by this development. Now, nobody is against the right to Symphony to develop their property. I think there are many things that, as elected officials, that you are reminded of, and it's your duty to research probably a little bit deeper as to what needs to happen with that plat and things moving forward. But we do appreciate the hard work and the dedication that you put in, as well as other officials like our police department. I think they, quite frankly, don't get enough appreciation set to them. So thank you for all that you do.
Thank you.
Thank you, Mr. Cutler.
My name is Cindy Garlick, and I live at 2164 North Frontage Road. I love this community, and one of the things that I love about it is that we proclaim that we want to defend our citizens and provide them with a healthy lifestyle and the opportunity to be happy and to have the things that we love and enjoy here. I think it's very important for us to remember that even though there is some litigation that needs to happen here, that maybe it is important for us to postpone a vote on this particular property until that litigation has been resolved. And my reasoning for that would be that I can see some cute little family coming into that subdivision, seeing on the plat that there's an easement across the back of their yard, putting up a fence that now takes away that easement and doesn't allow for access to the Packer property. Or I put a garden in the back of my yard, or a trampoline, or a swing set, or a playhouse, and now I have blocked Mr. Packer's easement. He is a longtime resident of this city, and he does deserve the opportunity to be able to utilize that property in the way that he sees fit to utilize it. And I love the verbiage in the document that he presented, that it was a perpetual easement. It stays there forever. It doesn't matter. It doesn't have to be propagated on every document from that time forward. And I think it would be wise for us to maybe consider that and look at the legal ramifications that come when a homeowner buys a piece of property, builds a beautiful home, and then comes to the city and wants to know why you didn't protect their rights before they even moved in. Thank you.
Thank you. Anyone else?
Okay, so my name is Brian Adams. I live on Carrington Lane here in Centerville. Lived here for about 3 years, and we love Centerville. And I just want to stand up and just kind of remind you, I guess, of what you all already know, right, of what your role is. It's not to adjudicate the issue of the easement, right? There's a lot of heartfelt statements that have been made on behalf of the Packers, and I fully appreciate that. I stand here on behalf of myself and my family, people that have moved from out of state and have come to love Centerville, right? We bought a house on Carrington Lane, by the way, has a very large easement on it, right? It's a very restrictive easement, right? We've had to live with that, and it affects us. I have young kids, but we love Centerville so much that we have been actually interested in this property that is owned by Symphony Homes and have been following it very closely because it is an area where we would like to move to, right? As a lawyer by trade, I understand the importance of easements and following them. I also understand that as a property owner, when you buy a property, and you know, Symphony has indicated that they are going to put a note on the plat, which provides notice to the individuals that would be potentially buying those properties. They have that notice. until that issue is adjudicated, right, there's still that notice there for those individuals. I don't see Symphony making any move that would be incorrect. By placing a note on there, it gives notice to potential property buyers that there's an easement here, and you'd be held to that, right? Or there's an easement in dispute at least, and once that dispute gets finalized, then they have that option, right? They have the option to move forward with purchasing that property or not, based on the dispute. So I want to speak sort of on behalf of Symphony in an effort, because I feel like that's a great development. I do agree with the Packers. Hey, if it's determined that they have right to that property, which is not your job as a council, that, fine, let's move forward with it. But as a homeowner, as somebody that loves Centerville, I have grown to just absolutely love it. I've looked at other places, believe me, Farmington, Bountiful, a lot of development. I can't justify moving there. I can't to any other city because I love Centerville. And even moving out of state, I've considered it, and I've always come back to Centerville, and I'm grounded here, right? And I would like the development to move forward. I think there's enough notice there for any potential buyer to understand the importance of easements. It's on the owner, it's not on the developer to understand what that easement means for you as an owner. And so I would like to see the development move forward because I'm interested in moving my family to a property that I think is more conducive for me and my children. So, thank you.
Thank you, Mr. Adam.
We got to get him on a few committees.
Yeah, exactly.
Landworks is missing a few.
Multiple committees. Any further comments from the public? So, Lisa, as our attorney, can I leave this hearing open, or do I need to close it? I'm concerned about closing it and having to open it back up. I mean, what's my options there?
Yeah, I would suggest closing it so we can have the different portion of our meeting, but in your motion, if you would like to continue the public hearing, or if somebody makes a motion to reopen it, you can do that as well. But just
Okay.
keep it in mind, if you're going to table it, decide one way or the other whether you would like to continue the public hearing, and we will.
Mayor, I'd propose that we close the public hearing. We'll probably table the decision, but I feel that we've, through all the steps of this process, given ample opportunity to hear the different points that are to be presented, and now it's going to just be up to us to make the tough decision.
Okay.
I would be inclined to agree with what Councilwoman Fillmore has said.
All right, thank you for, appreciate it, council and Lisa. So last chance to say anything on this public hearing, otherwise I will close the, oh, is there somebody?
I'm just wondering if there were some things that were said that might be helpful to the council if you'd like to.
When I close the public hearing, the applicant does get response, correct? Yes. So I will close the public hearing on the Summerhill Lane PDO. And now it is the chance for the applicant to respond to public comment.
Thank you. I just wanted to reiterate on what the requirement was. I have the transmittal from the final decision of the Planning Commission just to make sure that, the issue of notice has been raised several times. And this is what the Planning Commission required and what Symphony agreed to do. And so it's here on the second page and it's in your packet. But it says, the applicant shall add affecting lots 1 through 20 through 134 to plat note number 2 on the final plat. That's on the plat. And then the developer shall provide notice of claim of interest to potential purchasers of lots 120 through 134. We agree to that and we will do that. Some of this issue is moot if we I don't know, maybe it'll be tabled, but you could approve it conditioned upon putting that, just that one, that they call it the Drake easement, that we would consent to that. So if you want that, that would be fine. There was some discussion on on this number 9, which was a requirement or a condition from the Planning Commission. And I think there might be a little confusion there. There certainly is an error in what was described there, and it's pretty clear, and so staff can certainly deal with that, but I'm sure that they were aware of that, because the standard, it says the final plat, shall comply with Centerville zoning subdivision code 153030. That 153030, I had read that to you, that requires even the easements through claim of usage. Well, the Planning Commission cannot impose additional requirements upon you, the council. They don't have that authority. They have to find what is there, and so they either made a mistake by putting the wrong code, because the right code would have been 1503040 M, which would have been, but it wouldn't even make sense that they would be saying to you, the city council, the city council will require them to follow the code, which you're going to do anyway. So I would assume that staff looked at that and thought to give that any meaning, which staff would try to do, is to say they didn't really mean final plat. What they meant is the prelim plat, because it doesn't make sense any other way. And what was happening at the time, there was the issue, is it going to be on, is it not going to be on? And so the Symphony agreed through the settlement agreement that they would put that on the plat. And so that references that on that preliminary plat, you'll comply with 03030, which would be very appropriate. But it makes no sense if they're trying to tell you that the final plat has to have an ordinance that is designed for another process. It wouldn't be legal, frankly. So hopefully that gives some clarity to that. It certainly does not bind you to find, they couldn't create an issue to say, now because of what they said, the final plat, even though the ordinance doesn't require it, now has to have even easements claimed by usage. That would be inappropriate and not even closely legal. The other, on the gentleman that talked about he would like to buy that space, it is not a surplus space. It's actually planned into the project. There's 2 open space areas, one right here and then one right here on the west side. Both of those will be landscaped according to the landscape plan. They're both part of the subdivision plan, and they're going to have the signage which the subdivider wants. It will be beautified, and it'll have the entrance into the subdivision. There was discussions a couple of years ago, but it was not of any interest because it was part of the plan. And so it'll be landscaped and it'll be maintained, and it comports with the subdivision ordinance. So that's really not an issue. And obviously, if they wanted to sell, they would do that. They don't want to sell. They want that to be beautified. And the project is way too far down to start doing amendments. We've been at this for 2 years. I think that was really all I had, unless there's any other question that you might have. If not, then I'll leave that.
So council, I would turn it over to you if there's questions for applicant or for staff at this point in time.
Thank you for your time.
Thank you, Mr. Smith. If we don't have any questions for staff or applicant, then I guess I'm looking for a motion.
Well, I think that we have a lot that we need to understand from a legal standpoint on this. I mean, there's a number of issues. Some of them are not germane to our discussion. We've had a lot of conversation about easements, cover all the sins, and then that's fully disclosed. That still creates for me caveat emptor, buyer beware. I don't want to be in a situation where we're pitting property owners against each other in the future, because everyone's talking to us about what our role is, and our role has to be looking at the peaceful coexistence and the respecting of all rights. And I don't think we have a clear picture on a lot of these items. So I would prefer that we table this till the next regular city council meeting, and that later in the meeting I'll be motioning for a closed session to receive legal advice.
I'd second that.
Motion and a second, to further discussion? Let's just make sure that, by roll call, starting with Councilwoman Fillmore on that motion.
Aye.
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 That motion passes 5-0. Thank you, everyone. Thank you for your time, your interest in it. It sounds like we'll be having a motion later on closed session on this and further discussion on it at that point, but thanks.
Considering we're on item 1 of 13, can we take like 10 minutes?
Yeah, but I do want to ask before we do that, because I agree, is I need to get a feel of who's here for the next public hearings, if I need to rearrange the schedule at all. So internal
There's some out
ADUs,
in the hall as well.
raise your hand. Floodplain development, public hearing, Young Power Sports. So we have some from Young Power Sports, and pre-disaster mitigation plan, the chief. So, okay, that gives me a feel. Thanks, everyone. Yeah, take 10 minutes.
Does the chief have a futon in his
I gotta run
office?
home really fast.
Might wanna
Council's back in session. Let's move to item number 2. This is also public hearing on the zoning code amendments, internal ADUs. Corey, you want to talk to us about that quick? Or long?
Quick being the word here.
Instead of it takes very long, he promised to slit his wrists at voting.
Oh, sweet.
If you have a PowerPoint.
We're on YouTube.
I'm good with it. Thank you, Mayor and members of council. This is a text amendment, what you directed the planning commission and staff to look at, changing the duration of the time frame. Planning commission reviewed it. There's no hiccups in the general plan or the zoning order. And it's consistent with the state law as was requested, so we're recommending approval. Well, that's from the planning commission.
Are we doing zoning code amendments, or are we doing,
Sorry, have I got the wrong one?
We're doing zoning code amendments.
yeah.
I
So,
got worried I didn't know the order of the agenda right. Yeah, zoning code amendment. So it is a public hearing, by the way, to conduct a change to the zoning code.
thank you. There's no applicant on this, so this is a public hearing. Any questions for Corey? Okay, this is a public hearing matter, the zoning code amendments on internal ADUs, the definitions. And so that public hearing is now open. Those that might be online, please call in on the numbers, and those that are here, please come to the pulpit and identify yourself. We will give it just a few seconds if there is anybody online. Public hearing is now open if I didn't say that. Jennifer, anything coming through online? All right, we will close that public hearing, and we will come back to see if council has any questions for Corey or staff at all on this. If not,
I'd make a motion,
Thank you.
Mr. Mayor, that we approve ordinance 2021-25 with regard to the 183-day provision on zoning code, the zoning codes on ADUs.
Second.
we have a second. Any further discussion? Okay,
Thanks
let's,
for doing it.
thank you. Do a roll call vote, starting with Councilwoman Fillmore.
Aye.
Aye.
Hi.
Aye.
Aye.
That motion passes 5-0. Great. Let's go to public hearing on floodplain development variance with Young Power Sports. Do we have Dave or do we have Kevin presenting on this, or? So you want the applicant to go? You're deferring to the applicant first? Okay, applicant, come on up. Just identify yourself for us.
Ron Hales, Centerpoint Construction, representing Young Power Sports, a young automotive group. Jeremy Draper with Reeves and Associates, and I'm going to let Jeremy speak in behalf of the flood zone.
Thank you, Mr. Mayor, members of council. We've been working with staff on this particular project. It's right along the frontage road. It's next to the Dual Creek. Dual Creek is identified as a floodplain with the effective maps currently on the books right now. That's identified as an A flood zone. What we've done working with staff is we've modeled that. We've identified that everything that flows through Dual Creek and is a source of flooding actually stays within the culvert that goes underneath I-15. At this time, we've submitted all that information to FEMA. If you guys work with FEMA, it takes a long while to get that stuff approved. And so at this time, we've reviewed the variance process within your code, provided our analysis of each of the steps within that variance for council's consideration. One of the things I think that really helps us with this is we've done the technical studies, and we've reviewed that with staff, and everyone's in agreement that there's no real potential for flooding based on the information that we've compiled within that technical study. So what we're asking for is a variance with the floodplain so that we can construct, redevelop this building for Young Power Sports and get this going and not have to wait for FEMA as we go through this process, but be able to go forward with this. We see no life safety issues with proceeding with this as it's a commercial project, and again, there's no real concern with flooding based on the information we've presented so far.
What's the smallest culvert in the system?
So there's dual culverts going underneath I-15, and there's a 54-inch, and then there's also bigger box culverts. And so the combination of both of those holds the flow for Dual Creek.
Have they covered the creek next to where you're going to be building?
That was done as a city project just recently.
Okay.
And the study wasn't done, so we did work with the city in completing that study.
Can I say a few things? The whole reason that we're here is that what the Youngs have done, we're trying to expedite the construction piece. We've made significant investments both in the property. In fact, we just turned in the construction drawings for review this week. And we would love the consideration of starting sooner rather than later, instead of having FEMA have control of their business. So
What if FEMA denies it? Does that hurt you after we've given you the variance?
I'm going to let Nate or Jeremy speak to that.
So in the event that FEMA does deny it, we're still confident with the numbers that we've ran to show that there's no impact or flooding impact to these structures. One of the things that we do have with the structures is they're existing, being redeveloped, so the ability to raise or lower the structures just really isn't there. Just because we are trying to utilize the buildings that are there, just revitalize those. So as far as it hurting us, if FEMA comes back and denies us, no, it doesn't hurt us. I think if anything, it helps them define that channel from an A zone to maybe an AE zone that does have a base flood elevation. But again, I don't see that based on the information that we've reviewed and the technical studies that we've done, that would be an option for FEMA to consider.
Is the impact because of additions to the building and it didn't really apply to the existing buildings? Is that the reason for the difference? I mean, how did we get the older buildings there?
Correct. Yeah, so the older buildings are probably pre-firm buildings, so built prior to the maps being effective. And so per your city code and per a standard for FEMA, anytime you increase the value of the building by more than 50%, it has to be brought up to code. And so that's one of the things that, with the construction project and redevelopment of this project, we do exceed that 50% value, and so we are having to meet all flood code.
Dave?
Staff, we have a question.
When we did that big project up on the hill and it changed all the floodplain things, did that not affect this?
No, that alluvial fan just impacted homes down to about 400 east, about 181 homes, but it didn't change anything. A lot of this probably could have been mitigated when those culverts, the second culvert was put in on across I-15. It's just that at the time there was nothing for the city to really gain by investing all the money and time and energy into applying for this LOMR. So in talking with Kevin, we feel like the engineering's sound. We feel confident that it would be the case. As they mentioned too, in the event that they were to deny the LOMR outright, if they were to establish something like this AE zone, that does have that base flood elevation, and our ordinances do have protections in there that do require them to build a foot above that and to flood proof above that, 1 foot above that base flood elevation.
But if they've already started and built and that comes through, do they have to change it?
So the anticipation would be that it would be a ways out. They've submitted, they've probably got about 60 days left in the review period, which they'll have a determination. Infrastructure alone is
A
gonna be.
FEMA determination?
Yes, they submitted about a month ago, and they have a 90-day review period in which they'll give their findings. So within that period, they'd be able to make any modifications to their structures and that, and this would just really give them a boost on being able to start their infrastructure, because I imagine that's gonna be well past that 60 days. This just lets them get a jump start.
This doesn't give the city any liability if they do flood?
No, because they do assume, there's an assumption of liability that they've submitted and are willing to sign. In the event that they were to build and it didn't meet these, their big impact is to flood insurance to them, if anything else. They do have a financial motivation in all of this to stay compliant with the floodplain ordinance, because an A zone, for those that were around with that original one, those kind of flood insurance premiums are significant, to where homes were paying upwards of $4,000 to $5,000 a year. So if you can imagine, based on value, what the cost of this would be, I think there's a lot of financial motivation for them to make sure they're compliant.
I just lived on Porter's Lane once. So I just worry a little bit about you.
And the AE zone that he mentioned that they could find they have any findings to is more of a ponding. It wouldn't,
Yeah.
a catastrophic one, it'd just be a elevated one.
Well, worst comes to worst, they put up a flood sale sign and move that inventory and try again.
Start selling boats.
Right.
That'd be a bad day on my part.
Great.
No further questions for staff and applicant right now? Then this is a public hearing matter. Let's go to the public hearing part. So this is a public hearing on floodplain development variance with Young Power Sports. So that public hearing is now open. Those that want to comment online, the number's on the screen.
I know this is not part of the floodplain issue, but I do have a rendering, if you guys are interested, that I just received.
I'd love to see.
Would you be interested in seeing that?
Yeah, that'd be great. Let's just finish. Okay, you'll do your.
Okay.
Go ahead.
This is the latest rendering of the project that we just submitted. So that kind of shows you an elevation view of what we're doing.
Water tower,
Water
an existing
tower?
feature? No.
No.
To help with the floodplain, the water tower.
Catch it and suck it upwards, is that?
That's cool.
It's beautiful.
Boy, it is.
Updated, hot off the press, right?
Yeah, hot off the press.
Anybody online? Anybody in the audience? No? So we will close the public hearing on the floodplain development variance and ask council if they have any further questions. Everything Dave tells us and they tell us we're good legal-wise, Lisa?
Yes, I just want to make the suggestion if you could use the motion under the recommendation, because there are a number of items we're recommending the council approve the variance, as well as requiring the applicants to sign the assumption of risk agreement that's required by ordinance. And in an effort to expedite this matter, we've prepared these items for tonight. Oftentimes we come back with them, but they're ready to go. So we'd also like you to just authorize the mayor to sign those, so we don't have to come back.
Well, then I'm going to read your recommendation.
Yeah.
I would motion that we approve the Young Power Sports request for variance from the requirements of the city's flood damage prevention ordinance to develop commercial property located approximately 695 west, 400 south, subject to the applicant signing an assumption of risk and waiver of liability agreement as required by city ordinance, and subject to any additional conditions of approval requested by the city engineer. The mayor will be hereby authorized to sign and fully execute the attached variance findings and decisions in the assumption of risk waiver and of liability agreement.
Second.
Motion is second. Further discussion? Okay, I'm not going to repeat the motion. We have it down. So Councilman Ince, we'll start with you. We'll move in one.
Aye.
Robin?
Aye. Aye.
Aye.
Aye.
That motion passes 5-0. Thank you for coming. Thank you for hanging out.
Appreciate your time.
Yeah, we may have a restaurant that stayed open late if you want to shop Centerville. Okay.
Thanks, Dave.
Thanks so much. All right, let's go to our last public hearing matter. This is the Davis County disaster mitigation plan update from our chief.
Thank you, Mayor, Council. So, yeah, this is an update to the pre-disaster mitigation plan. This is a plan we've been working on for over about a year now. It is an update. The plan is one that is required by the federal government, FEMA, in order to be eligible for disaster funds. We've got to have a pre-disaster mitigation plan that's been approved. So this plan was kind of spearheaded by the county emergency management, and I sat on the what do they call it, the core objective committee or whatever it was, to help develop the plan. There was several meetings involved. So the idea of this plan is to identify threats, hazards and threats that we might have in our community, and develop mitigation strategies to address those threats, and then look at long-term mitigation plans and goals and objectives to look at ways that we can address the hazards that were identified, and then also fulfill the federal obligation, the mandate. So there's a 5-year plan to be annually reviewed and updated. After 5 years, and we'll have to go through this process again and adopt another plan. So the hazards that were looked at are the hazards that we've known about for years: the earthquake, flood, wildfire, slope failure, drought, dam failure, severe weather, the things that we're very much familiar with. The plan is countywide, but there is a specific area that deals with Centerville and what our hazards are here, which are all the ones that I just listed, and some of the goals and things that we are looking at to mitigate some of those plans or some of those hazards. Earthquake, we can't stop an earthquake from happening, but we have codes, building codes to address some of that. We want to do more education. I plan on getting started right off the bat here as soon as, within the next month probably, on starting the plans for a preparedness fair, another preparedness fair in September. We put that off for 2 years due to COVID, and I think it's time to get going on that. So that'd be a South Davis communities participating with that. Many things that were in the plan was upgrading the fire station. That's already happened, so we've already completed that. We're working on the drainages going underneath the freeway, and those are in progress, and we're in good shape there and on track. Water infrastructure improvements, so that's it, part of the plan. It's part of the 45-year plan that we have. Fire mitigation, so the FireWise plan. So each one of these areas, there's well, not every one, but there are some specific goals that we put in place in this plan to address some of these issues that we're looking at. So unless you have further questions, I would recommend that we go forward and adopt the plan as it's written. The deadline on it is mid-December of this year to have it adopted by all cities in the county.
I just want to thank you for your work, you and the county on that. I mean, that was a long document. It was in
Yeah, about 300 pages. It's
yeah.
And I should say that this plan has been reviewed by Utah Emergency Management, the Division of Emergency Management. It was forwarded to FEMA. Well, so Utah approved it. It was forwarded to FEMA. They have reviewed it and approved it. So the plan's been approved by those two very significant entities, and so.
George read it and told me it was
No,
really
full
good.
disclosure, I got to page 178 and then I ran out of time. So. But I am going to finish it. No.
Good for you.
But it did actually spawn one thought, which is as we have these plans of this level of detail, I think it would be important to communicate those to the council in smaller increments, like what is our plan for X area of town? Just as a vignette, when you're here for other business, just to say, let's take 10 minutes and talk about what this looks like, just so that the council has an understanding of that, and just on a repetitive basis, so that we eventually, I mean, for Bill, it's all clicked, but for everyone else, you know, it might be a little bit behind.
Great idea.
It's a big element.
The way Lisa approached the rewrite of the ordinance.
And with as much enthusiasm, so, you know.
Thank you.
Just give us a little bit at a time.
Just pick one disaster.
There you go. I don't see anything else for the chief right now. This is a public hearing as well too, so we will open up the public hearing for the Davis County Pre-Disaster Mitigation Plan. That is now open.
Yeah, presented other issues of like, what's the age of our generator here? Is it original to the building? We updated it? It's a good question.
It's original.
Randy and I did a tour that a while ago. I mean, we've run it a couple times, but. It might be aged.
Giving you of those of you online, if there's anyone, a few extra seconds.
The transfer switch, a leather glove, and a Frankenstein switch.
Jennifer? All right, seeing that there is no comments, I will close the public hearing, and we will come back to council to either ask further questions or present a motion.
I move that we approve Resolution 2021-27, adopting the Davis County 2021 Pre-Disaster Mitigation Plan Update as required by the Federal Disaster Mitigation and Cost Reduction Act of 2000.
Second.
Motion a second, further discussion? Let's start with, to my left, with Councilwoman Meekum.
Aye. Aye.
Aye.
Aye.
Aye.
And I echo the thank you.
Yes, thanks very much.
That motion passes 5-0. Thanks again, Chief. Okay, let's go to the moderate income housing and the report. What's this, our third one we're doing? Is this the third time on this, the moderate income report?
Probably the third annual report, yeah. Yeah, I think this will be the third posting. We've had some others, but they were spaced out every couple of years.
Yeah.
To them. Shouldn't be too much new news in the report, other than I'll highlight a couple of things. Each year now are required by December 1st to submit a report to the Department of Workforce Services, and then it's also submitted to the state, I think Community Development Office or whatever they call it. So we have to send it to them each year. We're required to review our goals and see where we're at with them. The fun part about this report is we finally get to highlight something that's directly matched our goals. Whether it's controversial, whether it works, whether everybody loves it, always debatable, but at least we met a goal. We got the ADUs adopted. That will cause us now, because I think under state law, we have to pick 3 goals. So we will have to update our moderate income housing plan, which is planned as part of next year's general plan update to we will be updating those and debating how we want to implement those goals. Another goal is being reported in a positive light. It's not complete yet, but our other goal is a third one, whatever program we can come up with and do, we've identified the general plan. We'll do a better job of tying in our transportation and our housing. It is required for us to do that anyway. So in that general plan, as part of the element updates, we'll better coordinate the housing with the transportation, the land use expected, and just take a look at where our housing needs are. And I think that's also a broad term, where our housing needs are for the future, as well as including in the moderate income housing update, selecting another goal or two or refining them during that process. So I get to report that to the state. That makes me happy because it's positives on our part. However, you're reviewing that tonight. We have to get it in by December 1st. I have one data thing that I'm still uncomfortable with. Jake Smith gave me some feedback that maybe I'm shouldn't be as much uncomfortable. But when you calculate your moderate income housing, you have to use the county's median income. And if you look at the county's median income, according to the state, we jumped to 122,000 for the county.
Say that again.
Yeah.
Median income for the
So we were all perplexed by this. and
Were
so
we in like the
uh,
70s before that?
2019 actually was 109,000. So we started looking into the data. And anyway,
So.
yeah.
We're sure it's accurate?
And when is the what is the county one now?
122,000 is the median income.
And what did we say ours was a year ago?
I think it was 98 or something off the state statistical records, 98, 97.
And my 108 data point was the census data 2019 American Community Survey data point.
So I'm looking,
So that, the positive, and this is my criticism of this whole system, so I'm just gonna be frank and honest with you. When you try to look at the moderate income housing, if we're placing it, and we indeed increase to 122,000, that bumps up the 80% median income. It increases the amount that we have. We went from 94 to 200 and something units that are marketable in that. Now, if you're really implementing moderate income housing, you're doing it based on how much money is coming into the community. And I don't know if that's really the most effective way to handle moderate income housing. But it does still create the disaster elements of 50% and 30% of that, which I think every community, and the law is only centered around 80% right now, but the reporting says you have to report your 50 and your 32, so that you can be aware of where the disparity is growing. And obviously 122 to somebody who's on some type of fixed income or a lower middle class wage, or even in, the poor category of less than, 25,000 or 30,000, it just shows that it devastates that part of the community draft. So,
Keep in mind, this is household income, right? So you have
Household
to.
income.
so I'm looking at it, that's 2025, right? In this document, 2025 projected median household income. Right?
And-
Okay.
and I'm wondering if it's-
122,602 for Davis County, 80,000.
yeah, and you also have to put a status of where you're at, so.
Did I miss that completely?
So it's a number that I'm willing to say, if you're okay with the base of the report, allow staff to verify those numbers and refine them so that if it is that much, that's great. If it's something less, we plug it in. If it's something more, that'll just frustrate me even worse. But let's get the right number that we feel comfortable with when we submit it, and allow the staff to make that kind of change to the document. It's not an ordinance document, it's just a reporting factor, and then allow the mayor to sign it so we can get it in by December 1st, so.
Yes.
It's somewhat related, but different question. What's happened in housing prices and rents in the last 6 months? What does that do to our record? That's got to kill it.
Yeah, if you, you see it I give that editorial in the report if you see it. And again, that's my way of poking the bear at the state and saying, this is not the best way of managing it, but we'll continue to try to comply. I don't want to be completely defiant, but, concerned. But what we've seen is, yes, there's been a huge influx of the housing prices. What we're seeing is not so much, there's still some growth in that housing prices. What the significant change that I'm getting feedback on is, instead of 80 people at the day you have the open house and at 10 o'clock you already have 80 offers, you're now seeing it extend out to a week or something of that nature where the offers are coming in. So you're seeing a little bit more days on the market, even though they're still fairly short. And the pricing is, what they're saying is that it's I wouldn't call it leveling off, but they're considering it some type of stabilization from what was happening.
It's selling more for the what it's appraising for rather than bidding over top of it.
So I can't say it's flattening, I can't say it's just more of a stabilizing the crazy raise in housing prices. But we're still a short supply in the building community, there's still, we're behind on the supply. Some of the estimates is it may still take 6 to 8 months to, I don't remember the number specifically, but there's a normal number of houses on the market in a stable place, and then we're still dropping fairly below that supply demand.
5% of that number, probably.
So we're still facing that housing crunch, but for now, we're seeing that crazy overbidding and done by 10 a.m. as soon as you list it. But my daughter tried to put an offer on a house yesterday, and somebody came in with a cash offer. And she's a teacher and single. So imagine what it's trying to, and teaches in Salt Lake area, Granite School District, and it's hard for her to get into a home, so. I don't know where it's gonna go. But my favorite town in Pennsylvania, Meadville, Pennsylvania, I can pick up a nice house for about 180 with about 3 or 4 acres. No jobs, but just maybe someday.
What are you saying?
Are you kidding? The grandkids are in Utah.
I was gonna say, your wife's not letting you leave the
Grandkids are in Utah. My fantasy is my own head.
So you're asking for approval on this, but
That you agree with the report, but that we can change those numbers
yes.
to reach a level and then report them to the mayor, and allow the mayor to sign the document and send it in by December 1st.
Yep. So moved. Second. Aye.
A motion.
Aye.
Motion is second. Any further discussion? Do you need a roll call, Lisa? Or can I get just, they're all doing ayes anyway.
We're already doing ayes.
Aye,
Aye.
Aye. Did Robin?
Aye.
aye. Aye.
Did I hear aye from George too?
Sure, I heard about 23 ayes, so.
That passes 5-0. If you guys are okay, I'm gonna move the chief and Alan up because Bruce is sitting at home in his house and they're here. It gives you guys some options if we move up the flock service agreement for automatic license plate reader data access.
Sounds like we need to get Corey some Pennsylvania.
Unless you're not ready.
For Christmas.
Oh, no, I'm ready.
Okay.
Thank you, Council. So flock safety, we have a contract from them that I think we've given you a copy of. But real quick, let me just explain my understanding of flock safety. They came and gave a demo to us, and it's not often that I am excited and impressed by a vendor, and this is one of those that has got me very excited, especially from an investigator this past. So flock safety runs license plate readers. They started out in the HOA business, where they'd set up an automatic license plate reader, entrance and exits to the HOAs, just to monitor who comes and goes. And what the cameras do is they take a snapshot of the back of cars, and they only take pictures at the back. And it takes like a digital fingerprint of the back, kind of like a facial recognition, but for a vehicle. So it keeps track of like where the lights are placed, the size of the windows, and it does the biometrics on it. And so it automatically knows, the make, model, year of the car. It also captures the license plate, and it captures bumper stickers, luggage racks, and such. And it keeps a database. And so flock safety has moved into the public safety realm, and they just moved into the Utah area. And there have been a number of cities in northern Utah that have implemented the cameras, including Ogden. They have quite a few cameras going. They've been going there for, I think, over a year now. And I spent a lot of time up in the Ogden area, and I didn't see them. I didn't know them. They were there, but they've been going. And so with this information, best I can tell, they've complied with
well, they do comply with our state law. According to the agreement, flock safety maintains data for 30 days. Our state law allows 9 months. For flock safety, after 30 days, their information is purged and requires a court order or some type of court document to be able to maintain, to lengthen that time. From an so it's something that we're considering and looking at for budget year 23 coming up. And that's down the road. So this is just a little kind of preemptive what we're looking at. What Flock Safety has done is, though, they're going to give us access to their databases, something they want to do for law enforcement for free. And so we're able to research and look through the database for, you know, for those cameras up in the Ogden area. And I know license plate readers are kind of a hot topic, and we know that going into it. And so there's going to be a lot more preparation down the road if we do pursue our own cameras. We know that there's going to be a lot of questions and concerns that we'll be ready to address. But from this, what we're looking at doing today is signing a contract with Flock Safety, which would allow us just to access their database. And they're pretty strict on the accessing it. You can't look into it just to look into it and see who's passed by. On every search, you have to put a reason code, which is something that's done within the CGIS systems already with the FBI. And so there's an audit that can be done. We track each search and the reason for it, who did it, and what was gathered by it. This agreement would benefit our department both an investigative standpoint. So if we have a unique vehicle, say you have a Subaru who left who had a bumper sticker in the bottom left corner and it had a weird looking luggage rack, you could do a search and maybe something similar is passed through the Ogden area and got picked up, and then we could get a license plate from that. And so, you know, the investigative standpoint from our side is going to be kind of limited because we're only searching Ogden's database, or I think Santaquin has some, and there's a bunch of you know, other parts of the country. But what it'll also do is give us a chance to kind of demo the program as we move forward and decide whether this is something we want to tackle as a city and an agency. As far as the agreement, I think basically just we're going to be required to follow the agreements which follow state law, which are actually more strict than our state law. So there's a lot to it, and like I said, it's something that I'm very excited about researching. And now every day when I listen on the radio and calls come out, it's almost every day I think, well, Flock Safety could have helped on that call. We could have figured out something on that. Even our bank robbery we had a few weeks ago, we ended up catching them, but it probably would have given us about a 2-hour head start if we had Flock Safety going. But, do you have any questions for me right now on it?
Due to the lateness of the hour, no, but I want to talk about their FedRAMP certification and the rest of the things that go along with that before we enter into an agreement, because privacy and security of the data is paramount. There's a lot of vendors that I'm seeing right now who are in the cloud. They've got cloud databases. They claim to be FedRAMP certified or CGIS compatible. And it's a can of worms. And if we are going to use it for law enforcement purposes, I'm totally fine with that. But I don't want back-end exposure that opens the city up to future liability if someone gets hold of that data. So I would want to fine-tooth comb the organization before we entered into an agreement.
Absolutely. And the agreement you're talking about, are you talking about the agreement today, or are you talking about
This is Ogden's data, but once you start collecting on behalf of the city using our funds, all of those caveats apply.
So you're willing to approve this?
This memorandum.
You just want additional before we sign our own direct agreement where we're collecting data?
Yeah, when we're generating data, we have, in my opinion, a legal obligation to go through all of the privacy and security from an IT and from just good practice standard and be FedRAMP compatible. So when it's somebody else's data, have at it, but when we're generating it in our city, there will be more questions.
Okay, any further questions for the lieutenant? And I guess we're looking at a motion for this memorandum of understanding that we have in front of us right now.
Who was it that signed it? Chief or the mayor?
Centerville Police Department and Flock Group are signing it, looks like.
I would make a motion to authorize the chief to sign the Flock Services agreement for an exploratory review of their software.
Second.
We have a motion and a second, further discussion? All in favor?
I assume that means we can look at Ogden's stuff.
Yeah.
With a reason code for 5 years.
That works.
All in favor?
Aye.
Opposed?
So some of this stuff works, because a
There's
couple of our
unanimous.
police cars are equipped to pick up stolen vehicles. And I had a pickup truck parked across from my house for a couple of days. My neighbor lady passed away, so I figured it was somebody over at their house. And next thing I knew, the police were all over it. When they came to work, he picked it up clear over on Porter's Lane coming to work into Centerville. And they followed the little beep and followed it right up there, and it was a stolen vehicle out of Bountiful. So it's pretty cool.
Good times.
I know they said they haven't found a lot of them that way, but it was still pretty cool.
Get all the good stories.
Great.
Oh, want one for my car.
Let's get back to item number 6. This is wetland improvements at Community Park. Pretty excited about this. Bruce has got on this. Thanks, Chief and Alan. Bruce, you sleeping or you with us?
I'm here.
Fire. We got an exciting document in front of us. Tell us about it.
So this is from the wetland consultant, has put together a proposal for both the dealing with the wetlands at the Parish Creek Pond area and also the west end of the community park expansion. And this is his proposals and the steps that he recommends going through in working with the Army Corps of Engineers to be able to move forward with the developments of the Parish Creek Pond Nature Park and also development of the west end of the park, the community park. So it's brought before the City Council both because it's over the purchasing policy requires anything over this amount to be brought before the City Council, and also to give direction on funding and if they choose to go, if they want to go ahead and have a consultant do this work. So if you have any questions, I can answer those. But if they're funding or financial questions, Jake is prepared also to give options.
And remind us again, Bruce, what's the total turnaround on this statement of work? How long has it taken to complete their efforts?
It doesn't give you, it's dependent upon the Army Corps of Engineers and their approval of the permits and that sort of thing. So I don't know that there's an exact date or timeline that he proposes.
Because to me, one of the goals of hiring a consultant would be to shorten the process as much as possible. So,
for sure,
if we're gonna pay this money, I'd like some reasonable assurance that they know the right people to call and they can bracket this into. Like, does this mean if we engage now, we can be pouring cement next summer, or are they talking 2 or 3 years down the road? What are we looking at potentially?
Oh, so the idea is to move forward right away with applying for the permits for the community park, but then July is when we want to this next step on the Parish Creek Pond area is to delineate as small of area that as possible. So we want it to be as dry as we can get it. So the idea is wait till July of next year, and then put together a new delineation map that will be presented so that we can only have to pay to mitigate as small an area as possible.
Remind me where the
What
Parish
is-
Creek Pond area is?
Is that the frontage road west of McDonald's?
I don't
Yeah.
always call them the right things, I guess. Okay.
Yeah, frontage road between Chase Lane and the first homes to the south of Chase Lane.
Okay.
Other questions for Bruce on this one?
Did you talk to anybody else about it? I have no ability to rationalize this price. Have you talked to anybody else?
So Dennis Winger is a wetlands consultant that we've used in the past. He was recommended to us from ESI, from Kevin Campbell, ESI Engineering, like I say, he has worked with us, helped us with other wetland issues and mitigation over the years. I haven't got a second quote from another wetland consultant, if that's what you're asking. But we have worked together and feel that he's very reasonable priced.
Did he help on the one where the parking lots are at Community Park, or?
Yes, where we had to work through some issues where we had we did not comply with some of the rules that were put in place 30 years ago and help us through that process.
And that was this Frontier Corporation?
Yes.
Okay.
He has done a great deal of work to this point without compensation to help us prepare, help us understand what our options are. So we engaged him shortly after the frontage road, the Parish Creek, the Parish Pond. We engaged him shortly after that. It has taken some time to figure out what our options are, and now we're ready to proceed now that we have options and we know what the cost will be to mitigate.
You're recommending it?
We are recommending this bill, yes.
One of the things that you've said as we've talked about this on 2 occasions is that there is substantial impact from the potential expansion of I-15. I guess I'm surprised that you're looking at dedicating the money this soon based on prior conversations.
So you're referring to the community park? The mitigating at the community park, or?
No.
The Parish Pond?
The Parish Pond.
Well, in terms of, if we mitigate and whatever cost we spend will be reimbursed by UDOT. Now, if that happens, and we have no idea where that I-15 widening, how that'll impact that area. We have some concept plans, but I don't believe that area is going to be impacted too much because you have frontage road. You've got the potential spewey coming down behind McDonald's that would be an off ramp. So anyway, we can proceed. So any costs that we spend today will be reimbursed by UDOT, including the mitigation costs, if it impacts that.
If it impacts.
Mm-hmm.
But is it assuming that then we've decided to do the pickleball courts in this location?
Okay, so now we have two separate issues. So community park, mitigating that side, we have designed the pickleball courts to be far enough back that if UDOT widens that road, it will not impact the pickleball courts. Now, whatever the frontage road, if it shifts to 60 feet and it takes on some of that wetland we mitigated, they would be responsible to reimburse us for that cost of mitigating the wetland.
But this contract is regarding that area.
So, right, so we're paying the contract to find out what those costs are. And UDOT, if they move any of their roads onto that property, have to reimburse us for our.
But the intention of paying this contract amount to this contractor is to be able to move forward doing pickleball courts in that
Correct.
area.
Correct.
Right.
But we can wait until UDOT mitigates it themselves.
That's not what I'm concerned about. I'm just
Right.
concerned that last time we talked about the pickleball courts, I thought we talked about having two legitimate options. And I've heard and seen discussion in the community weighing ideas on both properties and pros and cons for both properties. And one thing that I heard that piqued my interest was the idea, and I think maybe this got thrown out at our last meeting, maybe by you, Brent, but of like a dirt bike park that would be very affordable and possibly could incorporate wetlands.
That was not me.
That wasn't you,
I
but.
don't, yeah.
And that got mentioned again in the Facebook page where I read it. It was from a citizen, but, so it, I guess I would say it maybe feels a little preliminary for me, because I don't feel like we went through a full process and decided this is the spot. So to spend $30,000, assuming we've decided that.
Well, keep in mind, we're not beholden to pickleball courts. I mean, that's what we're proposing. But if we mitigate, it frees it up for whatever we want to place there. So regardless, we could mitigate and leave our options open. Bruce and I have been talking about pickleball courts in that location now for 2 years as a possible location.
No, it's definitely a legitimate possibility, don't get me wrong. But if we could possibly have an idea to do something there that would be of great interest to our citizens, and in that spot that needs mitigation, not require the mitigation, that's fascinating.
No, we can't.
You
we
have to
can't-
mitigate it.
You can't use it if it's not.
Yeah, we can't do any improvements at all. We're doing the maximum that they allow right now at cutting the weeds down. You're not allowed to disturb the surface or level it or anything like that.
That's the
So,
clarification I was looking for. So no matter what we do there, we have to mitigate.
I'm trying to imagine
this
that
is
the bike trail around it, right? We can't go in it or through it. It would have to be around.
Right, this is the
No,
first
I thought
step.
if we just left enough spots where the water could be captured. That was my mistake.
No, yeah, this is the first step required to be able to use that property for anything.
Then absolutely, yes.
Right.
Okay, thank you.
I'm glad we're able to get there. Sorry, I didn't understand.
Anything else for Bruce or the other staff on this one?
I would, a motion that we approve the permitting proposal with Frontier Corporation for the amount specified in our attachment.
Second. A motion and a second, further discussion?
I would love to see more bids on things like this. Just because we've used people before doesn't necessarily mean it's a good price. But where he's already doing stuff, I agree that we should pay him.
We did engage him early, because I agree with you 100%, but we engaged him early to try and be as responsive as possible. Now, it does take time, again, this whole wetland process, but that's why it was somewhat of an emergency. Let's engage somebody to move forward, primarily because of the Parish Creek Pond area.
Okay, roll call vote, Councilwoman Fillmore.
Aye.
Aye.
Aye. Aye.
Aye.
That motion passes unanimously. Let's go to item number 8. This is appointment of city representatives, Great Salt Lake Legacy Parkway Scenic Byway Committee. This has been around for a while. You don't hear much about it, but Brent and I talked about it the other day, and there's a resolution on this.
Calling him to Jake, I don't know why, but.
He's the party who got tapped.
Yeah, he is. Brent, you want to talk about this?
Sure, Corey's actually the one that could talk about it even more so than me. Corey has been our representative in the past, and he's going to miss it dearly. But we do need to reappoint Corey. Corey's missed a few meetings. So Gary Uresk has been leading this, the former city manager of Woods Cross has been leading this charge since 2008. He's done a phenomenal job, and really one of the primary purposes of this committee is to ensure that we protect the scenic byway. No billboards on Legacy. So you can thank this group for really fighting back, and they did their best to try and make sure trucks didn't get on, that weren't allowed onto Legacy. Lost that battle because that was an agreement made by the state legislature far before this happened. So anyway, it's a great committee. We need to have a representative on there, and I asked Jacob to represent the city on this. So that's what's before you. So with Gary stepping off, it's really, we need to find someone that's
I
going to
just
be as
want to know
passionate as
how
him.
hard he can fight for us, because in his current role, he just tries to stay pretty neutral. I've never seen like the fighting spirit. So Jacob, we need the fighting spirit here.
He's coming up for an interview here.
I'm afraid of you guys, so I gotta keep it neutral, but. No, I'm pretty vocal.
All right.
I make a lot of people upset.
Good qualifications.
Maybe not as much as Corey, though.
That's it, I have nothing else.
So
Go
what,
to and do the good work.
Okay.
is it strictly just billboard issues or are there other
No,
issues?
again, like the trucks, speed limits, anything to kind of just protect that scenic byway speeds, the environment, if you want to. touch on it.
Well, and then maybe I can ask the council right now what your position, if you have any position or opinion on that scenic byway.
Yes, get the trucks off.
And how it is right now?
Trucks off,
Get the
no
trucks off?
billboards.
Or are you standing up to come talk about it?
No billboards, lower the speed back down.
No.
The speed's fine.
Yes, you drive too fast anyway.
Limit's fine, but trucks and no billboards.
When Gary put this together, it was as it was finishing construction, and obviously there was that 11-year restriction on vehicles and so forth.
Gary who?
Gary, you're
Here, you're
Gary what?
City manager.
city manager of
Woods
Woods
Cross.
Cross.
Oh,
old
yeah,
city
yeah.
manager,
I
retired.
couldn't hear anything.
Sorry. And so he put it together trying to nominate that as a byway. It received a lot of controversy politically because it was the first byway done by this committee group rather than going to the state legislature. And after this was adopted as a byway, it stirred the pot a little bit, and the state legislature now is involved in saying that anything that's nominated, we get to take a look at before it is accepted. So it was done administratively. Originally, when the 5 cities got together, we funded $20,000 from Centerville and $20,000 from the other communities, hired a consultant, created a model ordinance all along the byway. That model ordinance I was involved with. All the cities adopted their own version of that model ordinance. So our Shorelands Commerce Park is fundamentally tied to that model ordinance that took in place. And then we had some meetings after that to talk about, the Office of Tourism is involved, UDOT representatives come to that meeting. Early on, for those 11 years, it was the issue of billboards and trucks. I kind of lost a little connection because the truck issue became so controversial, and I became a little uncomfortable about what Centerville's position was. And I raised that with Steve Thacker when he was here, because at that time, there was also the discussion of the inland port and the issue of how would that play a role, what would Centerville's role be, and I began to wax cold in the advocacy as a planner in that group because I didn't feel comfortable speaking for and on behalf of the city without a better process for the byway committee, because it's their own non-profit organization and you just give your 2 bits and they ask for 1 representative from the city. So you have Friends of Great Salt Lake, Office of Tourism, UDOT, the 5 cities, and the Wasatch Front. So the big thing was the trucks. That was a battle lost. The billboards are still a concern. UDOT's been great with us because we had the 2 trailers. There were signs out along the Legacy. They sent an enforcement letter, which got quicker action in the city. And then the winds came and blew them over, and they sit there doing whatever they're doing. But I think that's where Jake's going to be good, could pick up, because I think now they're going to go into the mode of what are some other amenities that maybe we could fund or get grants for. There's some education signs and opportunities on the south exit. If we developed a Shorelands Park, maybe a rest stop for the bikes or a trailhead in that area. They're looking at marketing. Is it another campaign of Life Elevated or the Great Salt Lake Elevated? That would be interesting. Elevate the Great Salt Lake. And
You do, it'll disappear completely.
and then, to mitigate the seisures that come with an earthquake. No, that's not good. That's wind events bringing in the water and flooding.
And there's still some question, when I was on the transportation board, years and years ago, they came from the state when they were building it and told us that there couldn't be big trucks put on there unless it was totally redone because it wasn't built heavy enough to handle the big trucks.
Like the
And then-
quieting asphalt isn't.
Yeah, they said if you do that within 5 years, you'll have to replace the entire, because it wasn't built to handle that kind of weight. And then when the inland port came and they decided they wanted to put the big trucks on it, nobody could ever remember saying that. We even went back through and proved they said it, but didn't do us any good.
I support Jake not only to relieve me, 'cause that's a very selfish interest, But I also think the idea is it's now gonna be, what is the byway? How does it benefit the 5 cities? Is there economic part of it? Is there some development that should occur to bring that as an icon and a branding? And so I think that's the real direction now, and I think Jake's role plays well into that, and it gets me out of doing it more.
So the no trucks thing, it's Corey's fault because he gave up on his advocacy.
Yeah, he
That's
got
what I
quiet-hearted.
heard.
If Corey was on there, it would definitely have been, you know,
Well,
dead in the water.
to-
It would
to-
not have happened.
To that point, in all seriousness, the inland port and the pressure to utilize that road, they need to keep that as much for passenger car traffic as possible. Even so much as I'd say if you're an inland port customer, you should be using the major corridor and not be allowed to use that. You should be local traffic only.
And you know, I hope it's not that Corey grew cold on that. I think Gary made a great ploy. UDOT representative said, you're not gonna win that battle, so.
As I recall, we signed as a whole council
Yeah,
a
we
letter.
did. We did.
Yeah, it gets that as well.
If they want to take it and go up Weaver Canyon, that's where, is their hope is, go from the inland port up to Weaver Canyon and on that road.
You're Teflon on it, it's fine.
Thanks. Okay, well, it is a resolution, so looking for a motion on it.
Make a motion that we approve the appointment of Jacob Smith as the representative of the Greater Salt Lake Legacy Parkway Scenic Byway Committee, 2021-39. Sorry, I missed that.
I'll second that.
Motion and a second, further discussion? All in favor?
Aye.
Opposed? This appears unanimous.
Thank you.
Thanks, Jake.
Do my best.
Okay.
Make us proud.
Passion.
Next item is a monthly financial report. Now, normally we have a presentation of it over when it's at the end of quarter, but we do appreciate Nate and what he's done on it, the highlights that we mentioned last time that he done. So, of anything that you've seen on that financial statement or those highlights, did you have any thoughts for Nate? Nate, was there anything you wanted to point out on it in particular? Okay. Any questions then for him on it? Because and like we'll continue to have him present on the quarterly statement. If no questions for Jake on that, it's there for you to look further, but I do appreciate the highlights and the things you pointed out. It was great in reviewing it, looking at it. Item number 10, minutes review and acceptance. We have 3 meetings that we're approving. November 3rd work session, November 3rd city council, and November 3rd closed city council minutes. Any changes on those minutes? If not, is there a motion to approve them?
Make a motion to approve the minutes from November 3rd work session, city council minutes, and the closed city council minutes.
Second.
Motion to second, all in favor, aye?
Aye.
Opposed? Thank you. City council report, Councilwoman Meekum, your turn tonight if
Keep
you
it
have
really
anything.
quick. The transportation committee is kind of fizzled out. I'm not getting anything from them, so the 2 people that were head of it are both gone, and I'm not receiving anything.
Really?
The Utopia, there's not a lot of new. Last time I talked to you about the fact that they're going in and helping other cities and just taking the money. I mean, they're not going in and putting the physical, but they're offering their services to help them get set up. They've got them to Idaho Falls even, and they're bringing in some money and hoping to bring some money in with that. Other than that, there really hasn't been anything major that.
What return do we get on that? Just contractual payment?
Yeah.
Utopia provides the customer service side,
Yeah.
Oh,
not the infrastructure side.
And it's actually,
it's
we
an
get
ongoing
like,
contractual
and we actually
agreement.
get quite a return on it.
Yeah.
And so, yeah, it's a good thing. And then, of course, they're saying they're trying to figure out how to get it back into Utopia so that they can pay us back. So hold your breath on that one. That's my own commentary.
Better said, don't hold your breath on that.
Yeah, don't hold your breath on that one.
That it?
That's it. I was quick.
Okay. Mayor's report, I'll be quick as well, lateness of the hour. Appreciate Bryce and the program he put together up at Freedom Hills. The speaker was good, the presentation, you know, of the colors was fabulous. It was nice to have that. Unfortunately, the weather behaved, and we were able to pull that off, and it
The
was.
weather wasn't bad.
Yeah, yeah.
Oh, I thought you said unfortunately.
No, fortunately, the weather behaved, so, yeah, so, it was a neat
Did we
event.
figure out what's wrong with the flagpole?
You know, Bruce got the flag down, right after, so I guess maybe it was just getting stuck or something, so. Yeah, so you gotta work it. Oh, and as a highlight, of that, this poster board, paper you see out here in the foyer, that came from that, where you can sign there and it will go to troops, you know, as a Christmas present for them to read messages. So that's what you see out here in the foyer.
I thought it was going to the Veterans Center down in Payson.
Veterans Center, yeah.
Okay.
Yeah, you're right. Yep.
Changes the message a little bit.
Yeah.
Troops versus veterans, right?
Thank you for, Councilman, for correcting me there. And then the other thing is LPC starting up. There was a meeting yesterday that I attended by Zoom. I caught a portion of it. Then we'll have another meeting in December. Then in January, of course, it will go weekly. And along those lines, we want to be as active as we can. I will do my best to bring back to you. And we also have Brand involved there. And Bill, I need to talk with you, see if you still have interest to be involved this year.
Yeah, I'd like to.
Okay. So we can stay on top of the issues, and in conjunction with that, you know, we will have, we've confirmed 2 of our representatives to be here on December 7th to discuss some of the things that you submitted of topics of concern to you. Brand and I and Councilman Ince will bring back to you what's going on with LPC. And like I say, it's monthly next month, and then starts middle January, weekly during the session. That's really all I have to report. I went to a Wasatch Integrated Waste Management meeting. They just presented the financial statement audit. That was the main thing, and asked a bunch of questions and things look good on that, but in the last couple of weeks. So, Brent, unless there's any question, Brent, City Manager report.
All right, thanks, Mr. Mayor. I'll start off with the Justice Court. Really wasn't going to be a huge discussion in my opinion, but I'll present what we've done at this point where we can take it back. Justice Court hours are going to change to 9 to 3. Just so you're aware, we're a Class 2 court, which we're required based on our caseload to be open 5 hours a day, a minimum of 5 hours a day. So one of the challenges Tammy's having is being open 8 hours. She doesn't have time to catch up on minutes or calls or anything like that. So by reducing these hours to 9 to 3, which really is similar to what the county does and other justice court, gives her that time to prepare in the morning and time to end the day. So that's what we're recommending. We did hire Ember. She's a new part-time employee. We're excited to have her. Don't believe she has any court experience, but she is, she's very knowledgeable. So we're excited for her. Tammy's very excited for her. So where we are, any recommendations forward for Justice Court from us is to evaluate that pay, again, to be competitive. It was a tough time hiring. I think we're fortunate to have Amber at this point. But we need to look at the pay, and we could potentially look at the idea of combining the 2 part-time employees into a full-time. The way we're staffed is very similar to North Salt Lake. North Salt Lake also has 1 full-time and 2 part-time, and they have a heavier caseload, so we're not off base. According to the Class 2 requirements for our court, a minimum of 1.5 FTEs. Currently at 2.25 FTEs, so we're staffed appropriately. But Tammy, the big point is just trying to address that pay. We're reducing the hours, so if you get any questions, that's really what we're trying to do. So we'll be open all day on Thursdays, though, when we have court.
Does that change the amount we pay the judge?
No, not even a little.
Good question.
So,
So the wages will come up with everybody else's?
when we discuss this
We
July
discuss all
1,
that.
again, this is across the board, and we just need to evaluate all the positions, and this is going to be one of them. I've reviewed when we had that presentation from the judge with the potential reform of the Justice Court statewide. I did review, I got hold of the document and reviewed it, and they are proposing this, that they'll take this to the state legislature, the 2023, and if it happens, there's no need for cities to be in the Justice Court business. That's how bad it could be.
Would be sad.
They're gonna take everything that's not an infraction. They're basically taking the revenue from the cities, and they'll keep us with infractions. I won't go into detail right now, but we'll see where.
So is that something somebody put on the list for our meeting with legislators next month?
It should be.
We could. Like I said, it's gonna be a 2023, so it's next year. Roger, too, just, you might know him. He's kind of our representative from the league on this issue, and I would encourage you to have a conversation with him as well. If you want this to be on December 7th, we could. It's not gonna be an immediate issue, though. That's not gonna be discussed in this legislative session. It might,
I
we
hear
might
you,
waste
but-
our time. But I think in the off term, right, in between sessions, we should have the conversation.
Well, and I don't know that I think it should be mentioned as, assuming we feel strongly, I think it merits 2 minutes of mention.
Yep.
Not much discussion.
Yep.
Well, I kind of need to wait for the document to go officially public, and that way you as a council can have more information, so I don't know if we
That's
should
fair
bring it
enough.
up yet until you have all the information to challenge them on items that you think need to be challenged.
I'll just mention that we have a concern.
Yes, absolutely. Young Power Sports, I did want to mention that they will be at the RDA next meeting for the creation of the CRA, just so you know. I know there's always a concern about creating CRAs and these incentives after the project's done. Just keep in mind, we've been working on this the whole time, and just want to keep you in the loop that the formation of the CRA will be presented December 7th in an RDA meeting. And then animal control, that was brought up earlier about the raccoons, so I've definitely conveyed that to Davis County this whole time. Ashley, they hired a new director, her name's Ashley. I expressed that to her. I says, look, if you're not gonna offer the service, at least when they call, can you have a list of names or have a relationship with a private contractor that can come do it? Because right now we have residents trying to find somebody and they're getting charged $250, $300 to deal with a raccoon. And she says, we're actually looking at taking it back in-house. So,
Good.
positive news. I says, at a minimum, can you figure out a list of exterminators that can come out, provide assistance for residents? So, we have a meeting, I have a meeting with her, I believe on Thursday. of
Does
city managers.
Ashley replace the director that was there for just a short period
Yeah,
of time?
replace Roland Cook.
Excellent.
Ashley was the assistant, she was the interim. She's very sharp, so pretty excited to work with her. That's a tough job.
Yeah.
And last, Councilmember Ince asked me about the walking tour, so I'm gonna, since Corey, you're here, I'm not gonna read what you wrote and shared with me. Can you come up here and share kind of the walking tour?
Not in real time, highlights.
Yeah, yeah, exactly. It's about 3 hours, let me
We
talk you through
started
it.
at this corner and we talked UDOT, as part of their expansion, has gotten, I think it's called, Smart Growth America.
Smart Growth America, yeah.
Smart Growth America. It's involved in their environmental impact statement. So I'm assuming it's responding that we're requesting for federal funds. And as part of that EIS, this nonprofit group, UDOT is partnered with them. I got the notice just a few days before too, so it's something that I was like, oh, walk in Centerville, about Centerville, I think somebody's gotta go. We did have several staff there. Engineer was there, we had Kevin Daly from the Planning Commission showed up, Mark Marchant, I was there, McKinsey was there, so, we did have some staff there and some discussion. Horrocks is their consultant, UDOT was there, Wasatch Front Regional Council was there, and so we split up into two groups, started at America First and walked all the way to Legacy in two different groups. The concept of Smart Growth America is to look at those alternative transportations, particularly biking and walking. Seeing what's there in the community, what are the problems with it, what's the design issues, what's the user issues. They're reporting through the cell phone data that that bridge is a hot spot. So it is getting,
Hotspot, what do you mean?
for
hotspot?
walkers and bikers, it's showing up.
Heavily
It's being
used.
used. Now, how hot, what's the heat map? I don't know. You know, is it blue or is it fuchsia? I don't know. So, they understand that. They're talking on a big picture level, so it went from just, well, here's what you have, what are you dreaming about? And we met in a Zoom meeting after the next day, talked with the groups, they wrote down notes. We talked about a lot of things, the design, what Parish Lane, the interchange, the trail systems in the community, you know, some of the problems that we see, like the walk signs like this and like that, and so you can't get across the ramp without going, well, I hope it's green. You know, there's a lot of design problems that way. So they've compiled that, they kept plan on April coming back and introducing the next level of discussion. Now that I'm on the list, hopefully I can get it earlier and I can keep you informed on what they're doing. But it is attached to the EIS program. They put the Seattle, have you ever been to Seattle and see the overpass that's over the roadway network? You know, it's probably $500 million to construct. Really cool. They showed a picture of that. And Mark was right on the chat going, that looks expensive. And so that discussion came up and UDOT says, just brainstorm now and, you know, we'll have future discussions. So they're thinking big. We talked about multiple bridges across I-15 for pedestrians, community park, border. Should it be a part of this thing, the SPUI thing? SPUI, should it be separated? I mean, there's a lot of brainstorming. So I think it was good, but I also think it's one of those where the nonprofits coming in and they're seeing things from, you know, Chicago point of view. We're seeing things from Centerville point of view of, you know, they're saying, can you justify the impact through economic development? Well, yes, but not something like that, probably. So I think it'll narrow itself down. But it was fun, actually, to get out there and walk and watch the best one is the mom coming to the 7-Eleven, jumping the barrier on the landscaping with a stroller. That was fascinating.
Thanks, Corey.
And are they planning on having drivers drive on the left side of the street so that they can optimize whatever? That makes me so
Down
crazy.
in St. George Boulevard.
There
I
are
didn't hear that
several where
I
they're
didn't
doing
hear that
it, so I'm
specifically
hoping that's
discussed.
not.
I'm just familiar with the old design that's taking the tunnel off to the frontage road. I didn't hear, what they call that. There's a term that they use that to eliminate the lefts. Turn congestion.
Yeah, there's one on 2600 South.
Yeah, 2600 South has the same thing.
And I-15.
They're
St. George,
annoying,
if you've
and
been
they,
there,
and they
happened to
increase the
visit.
wrong-way
Yeah.
drivers on the freeway.
St. George at the St. George Boulevard does the same thing. There's several of them along the way, but that wasn't really discussed at this
Good.
point.
If you can keep that from being discussed and not an option at all, that would be awesome.
No left turns, ever.
No,
I just didn't.
no crossing.
No crossing
Drive
traffic.
on the wrong side of the street.
Through turns
Welcome
all
to
over.
America.
I thought a big roundabout right there at Marketplace would be great.
Oh, maybe a roundabout over the top of the freeway.
Honestly, I think the interchange will be designed, most of the SPUI can fit, traditional SPUI can fit
What is a
with.
SPUI?
A SPUI is a single point interchange where you have that common light.
106 South in Sandy, where you can go under the freeway when you get off when you're heading northbound. You go
6
under.
north in Salt Lake.
And you just connect to the frontage road, so you don't have to get up there.
Oh.
And then deal with it.
So
People going
So it would
north to
actually
the
come,
front
so if
can
you're
go
heading
from
northbound in
that
Centerville, the idea is you would go under Parish and the light would be on the other side of McDonald's.
Be way cool.
So I'm not sure it's wide enough to do what you're talking about without condemnation, but
Good.
still noted.
Thank you.
All right, thanks, Corey. Mr. Mayor, that's the end of my report.
That's it.
Corey's
I have
report.
one question. Scablin Park signage. I don't think we have any.
So Bruce and I just talked about that.
Oh,
Our
awesome.
contractor has not been cooperative, and it's a small job, so I asked him to look for someone else.
Okay.
So we have not forgotten. So
Awesome. I appreciate that.
I'm a little frustrated with that. It's a small job, and there's bigger jobs, and so the contractor has not been working with us, so.
That is
Again, we do want to address the Reed Smith sign as well, unless Councilmember Meekham's husband wants to design a whole
Want me
new
to go
one.
back, you want me to go back out in the wood shop again?
Yeah. Bigger.
Tempted.
Bigger.
I'd like to see Dixie be able to see that.
Right.
I think that's important.
We do want to address that one as well and make it really nice. And then we'll put the other sign in Councilmember Meekham's yard in the front. So-
All right, it's late, but we do need a closed session,
I
so.
move we
need a motion.
adjourn and go into a closed meeting for receiving legal advice
Discuss reasonably.
and reasonably imminent litigation with no intent to return.
Second?
Second.
All in favor?
Aye.
Aye.
Opposed? Council's closed.